Good morning, everybody. So I will speak in Arabic language, so you should make your hand phone. We are in the era of the IA. صباح الخير للجميع. الجلسة مفتوحة. معالي رئيسة المحكمة الدستورية لجمهورية جنوب إفريقيا السيدة مانديسا مايا، أصحاب المعالي رؤساء المحاكم الدستورية والمحاكم العليا، أعضاء المحكمة الدستورية لجمهورية جنوب إفريقيا المحترمين، الحضور الكرام، أهلا وسهلا بكم. في هذه الجلسة الثالثة بداية دعوني أقدم لكم نفسي. الأستاذ عباس عمار، عضو المحكمة الدستورية للجمهورية الجزائرية. لكن قبل الشروع في أشغال هذه الجلسة اسمحوا لي أن أبلغ خالص الشكر وتقدير معالي رئيسة المحكمة الدستورية الجزائرية السيدة ليلى عسلاوي، المعينة مؤخراً على رأس المحكمة الدستورية الجزائرية، خالص شكرها وتقديرها لمعالي رئيسة المحكمة الدستورية لجمهورية إفريقيا الجنوبية السيدة مانديسا مايا على الدعوة الكريمة للحضور والمشاركة في هذه القمة، كما تتوجه بتحياتها الحارة لرؤساء المحاكم الدستورية والمحاكم العليا لقمة مجموعة J20، ولأعضاء المحكمة الدستورية لجمهورية إفريقيا الجنوبية المحترمين، كما تشكر لجنة التنظيم على تشريف الجزائر برئاسة الجلسة الثالثة، متمنية لهذه القمة النجاح وأن تتوج أشغالها بنتائج ترضي تطلعات شعوبنا. شكرا. نعود إلى موضوع الجلسة. موضوع هذه الجلسة يتناول عدالة تغير المناخ أو العدالة المناخية من خلال التعاون القضائي. إن موضوع هذه الجلسة لا يقل أهمية عن المواضيع التي تناولتها أو ستتناولها الجلسات الثلاث، سواء حول استقلالية العدالة أو حول الذكاء الاصطناعي أو حول الجرائم السيبرانية. إن لم نقل أن هذه الجلسة المتعلقة بعدالة تغير المناخ والتعاون القضائي قد تكون الجلسة الأهم أو الموضوع الأهم، لأن تغير المناخ أصبح له آثار خطيرة تهدد حياة الإنسان، وهو أقدس حقوق الإنسان وهو الحق في الحياة، لأن الاحتباس الحراري أدى إلى تغير الطقس وإلى ارتفاع درجة الحرارة وارتفاع منسوب مياه البحار، وأدى إلى الفيضانات، وأدى إلى الجفاف والتصحر والمجاعة والفقر، وأدى أخيراً إلى النزوح بسبب تغير المناخ. هذا ظاهرة جديدة يجب أن يعترف بها من أسباب اللجوء، بل يكاد اللجوء بسبب المناخ يفوق أعداد اللاجئين بسبب الحروب. هذه الآثار السلبية هي التي دفعت العالم إلى صياغة آليات للحد من هذه الآثار، سواء من خلال اتفاقيات الإطارية للأمم المتحدة المتعلقة بالمناخ، مروراً ببروتوكول كيوتو التابع لها، وصولاً إلى قمة باريس حول المناخ سنة 2015. كل هذه الآليات كانت بهدف التقليل من هذه الآثار السلبية لتغير المناخ، لأن هناك مساس بحقوق الإنسان، بحقه في بيئة سليمة وصحية، وحقه في الحياة، وحقه في مناخ صحي، وحماية الأجيال القادمة في حقها من الثروات الحالية وعدم استنزافها من طرف الأجيال الحالية. إن العدالة المناخية التي تعني أن الفوائد المحققة من الأنشطة التي تتسبب في تغير المناخ وأعباء تغير المناخ يجب أن توزع بعدل، ويظهر ذلك على 3 مستويات. المستوى الأول هو العدالة بين الدول. يجب أن يكون العائد أو الربح الذي تجنيه الدول المصنعة من آثار تغير المناخ يجب كذلك أن يقابله تعويض للدول النامية المتأثرة من تغير المناخ. المستوى الثاني للعدالة المناخية هو العدالة بين الأجيال. يجب على الأجيال الحالية أن تضمن حقوق الأجيال القادمة في الثروات الطبيعية ولا تستنزفها بشكل غير معقول. والمستوى الثالث للعدالة وهو العدالة داخل المجتمعات، خاصة بحماية الفئات الهشة والمجتمعات الضعيفة من الآثار الوخيمة لتغير المناخ. إن الآثار الكارثية لتغير المناخ أدت إلى تنامي التقاضي المناخي، فأصبح الناس يتجهون بشكل متزايد إلى المحاكم، سواء على المستوى المحلي أو على المستوى الإقليمي أو على المستوى الدولي، بهدف مكافحة أزمة المناخ لمحاسبة الحكومات والشركات، وأصبح التقاضي بذلك آلية لضمان العدالة المناخية. وقبل ذلك استطاع القضاء بصفة عامة والقضاء الدستوري بصفة خاصة أن يلعب دورا متزايدا بمحاسبة الحكومات والشركات. ولنا أمثلة في ألمانيا حول سياسة المناخ، مثال في هولندا، ومثال كذلك في جنوب إفريقيا من حيث الاعتماد على الحق في حماية صحة بيئة سليمة. وبعد الرأي الاستشاري الأخير في 23 يوليو الماضي لمحكمة العدل الدولية حول المسؤولية القانونية للدول عن تغير المناخ، والذي كان رأيا تاريخيا بسبب التصويت عليه بالإجماع، لأنها المرة الخامسة منذ إنشاء محكمة العدل الدولية التي يتم فيها التصويت على رأي بالإجماع، وبمشاركة 91 دولة و11 منظمة دولية. إذن هذا الرأي الاستشاري الذي اعتبر أن الدول مسؤولة عن تغير المناخ، وبالتالي هي ليست مسؤولة سياسيا فقط وإنما مسؤولة قانونيا، وبالتالي فهي مطلوبة بالمحاسبة وتعويض المتضررين. إذن هذا الرأي فتح المجال لتنامي التقاضي الدولي والتركيز على التعاون القضائي على جميع المستويات. وفي مجال التعاون القضائي يعتبر الاتحاد الأوروبي ودول جنوب شرق آسيا نماذج ناجحة يمكن الاقتداء بها لتبني التقاضي البيئي، ولكن رغم ذلك ما زالت هناك عوائق تعرقل التقاضي المناخي. وهنا نصل إلى الإشكالية التي ستتناولها هذه الجلسة. فما هي سبل التعاون القضائي؟ وما هي الحلول المقترحة لتذليل العوائق؟ هذا كل ما سنعرفه من خلال المداخلات التي سيقدمها زملاؤنا الأربعة المتدخلين. ولا أدري هل بالصدفة أم كان هذا مخططا، المتدخلين الأربعة يمثلون 4 قارات: أستراليا، أوروبا، آسيا، وإفريقيا. وهذا شيء جميل، لأن الظواهر المناخية والبيئية لا تعترف بالحدود، وإنما هي ظواهر عابرة للقارات وعابرة للدول ولا تكاد تستثني أحدا. إذن سيتدخل معنا السيدة جين جاغو من أستراليا، السيد جاك ميزار من فرنسا، السيد أرسول ساني من أندونيسيا، والسيدة لوتشيا ريبيرو من الموزمبيق. المتدخل الأول هو السيدة جين جاغو. السيدة جين جاغو جاج هاي كور أوف أستراليا. Jane Margaret Jago was appointed to the court in October 2022. She was a judge of the Federal Court of Australia from 2008 until her appointment. Between 2006 and 2008, she was a judge of the Land and Environment Court of New South Wales. Before her appointment as a judge, she practiced as a solicitor between 1991 and 22, and as a barrister between 22 and 26. The floor is yours, Madam. Thank you very much. You have 20 minutes to present your paper.
Thank you.
Thank you very much.
Thank you. Chief Justice Maya, and to the organisers of this conference, thank you very much for the opportunity to speak to such an esteemed audience. I'm here representing our Chief Justice of the High Court of Australia, Chief Justice Gageler, who sends his warm wishes and thanks. I feel as if I've come from one great continent, the continent of Australia, to this great continent of Africa, for me, for the first time. It does seem appropriate to be speaking about the issue of climate change in this location, this mother continent of all humankind, in circumstances where the threat of climate change is one to all humankind. I am going to speak from a distinctly Australian perspective. We are a common law country. We are a common law country which is a federal system having both Commonwealth Parliament and also parliaments of states and territories. One of the distinct features of the Australian system is that, unlike many countries, we do not have a freestanding and separate form of a Bill of Rights. We rely on the strict separation of judicial power, which is embedded in our Constitution, so that only the judiciary are capable of exercise of judicial power as a source of the protection of people from the overreach of governments. And so what I want to speak about is the possibly unique challenge, difficult challenge that climate change litigation presents to the common law system. In Australia at present, there is a clear distinction which exists between the approaches of the courts applying common law doctrine to climate change litigation and what I might describe as the robust regulatory approach of our Commonwealth and state and territory parliaments to the issues of regulating climate change impacts. At the moment, there might seem to be a divergence between those two spheres of political and judicial activity. But of course, one of the features of the common law is that it always responds to legislative and regulatory change. It is modifiable by statute. And what I anticipate is, with increasing regulation in Australia, there will be greater convergence in the future. The first topic I'd like to address is what do we mean when we say climate change litigation? The description seems to be applied to so many types of proceedings. In reality, some of those proceedings do not have a direct link with the risks to humanity presented by climate change. And these kinds of proceedings, in my view, don't present the same kind of difficult challenge for common law doctrine as what I'm going to call climate change litigation proper. So, for example, there are many greenwashing cases, including in Australia, and these are often called climate change litigation. In reality, from the point of view of legal doctrine, greenwashing or conduct that misrepresents the environmental credentials or performance of some entity or another presents no particular legal challenge to common law theory. It is capable of being determined within the framework of existing common law doctrine by references, for example, in the common law to fraudulent or negligent misrepresentation, or under statute law in our country, a statutory proscription against misleading or deceptive conduct. We also have administrative law challenges, what is called judicial review of administrative action for legal error, and such as the relevance of climate change to administrative decisions. Again, in my view, this kind of challenge presents no particular novelty in legal principle for the common law judicial method. These cases are well able to be determined within a framework of existing precedent. So, I'm not going to talk about those types of cases. I'm going to talk about what I call climate change litigation proper. That is, a case in which a person or group's claim for relief, be that relief pecuniary, declaratory, or injunctive, depends upon the assertion of some duty or right in respect of impacts on the climate. Now, these kinds of cases, in my view, are different and do present a difficult challenge for common law doctrine. It might be said that the challenges are unique, but in the history of the common law, there are analogies. Why then is the common law challenged by this kind of litigation? It arises from two types of characteristics. They are cause and effect characteristics. The first is that the causes of global climate change are themselves, of course, global. Virtually all human activity, directly or indirectly, contributes to climate change. So what we have is an almost limitless spectrum of causes of climate change. Now, the challenge for the common law orthodoxy is that while the common law has never required a cause to be the sole cause of any claimed harmful effect, it does depend upon proof of causation, at least in some material way. That is, there needs to be some obvious material contributory effect of the alleged cause. Now, this creates a particular problem for global climate change cases in Australia, where the causes are almost infinite in their variety. And this is what has been called the drop in the ocean problem of causation, trying to identify what actual effect the act or omission has had on global climate change. Now, just as the causes of climate change are infinite, the effects of climate change are also global and diffuse. It is true that the effects of climate change are far greater and more immediate on some countries and some peoples than others, and I'll come to a particular example in Australia of a case brought by the Torres Strait Islander peoples who inhabit the Torres Strait in the far north, beyond the far north of Australia, in the waters of the Torres Strait. The global effects of climate change create another difficult issue. The issue is when everybody is or will be affected in some or other way by climate change, how does the common law choose between the potentially competing interests of people, including between people who exist now and people who will come into existence in the future? The issue of intergenerational impacts of climate change. Administrative theorists would say that the issue of climate change is fundamentally polycentric in terms of its causes and effects. Now, to date, at least in Australia, this has presented climate change litigation in the narrow sense that I'm describing it, with peculiar difficulties. And the two cases thus far which fall within the pure common law claims within the framework of climate change litigation, as I have defined it, have clearly exposed those difficulties. In short, at different levels of the judiciary, one a decision of an intermediate court of appeal, and one a single judge decision of a superior court of record, both claims have been rejected. In both cases, the courts considered the issues raised by the alleged common law duty of care, recognising that we're in a system that does not have a Bill of Rights, so it has to be brought within a common law framework. The issues have been seen as essentially non-justiciable. That is, that aspects of the claims are beyond the jurisdictional competence of the courts to resolve. The claims have been treated as only resolvable in the political, not the judicial arena. Insofar as the claims have been justiciable, the allegations of a common law duty of care on the government or arms of government to act in a particular way in respect of the risk presented by climate change has been rejected. The first case was one called Sharma. It's a relatively recent case. At first instance, the claimants were successful, but it was unanimously overturned by an intermediate court of appeal. The issue was this: in deciding whether to grant permission to a new coal mine, did the Minister for the Environment, the Commonwealth Minister, owe Australian children a common law duty of care to avoid the risk of harm to them from the emissions of carbon dioxide caused by the ultimate combustion of the coal which would be extracted from the coal mine and exported overseas for use. Now, the issue of the fact of climate change and the seriousness of the risks it presents was not in dispute. That was an accepted factual substratum. The court accepted that relatively common position of the parties. It rejected the existence of the alleged duty of care. In doing so, it called in aid various factors said to indicate the essentially non-justiciable nature of the underlying considerations said to give rise to the duty of care. They come down to two essential features. First, the view is that the government responses to climate change are matters of core or high government policy involving a multifactorial consideration, and these are policy choices to be made in the political arena. Second, that the courts have no legal standards by which to judge the reasonableness or otherwise of those high policy choices, and it was said were not able to develop these standards by any legitimate common law method of reasoning. The consequence was that the court in that case rejected the existence of the claimed duty of care, saying that any relevant duty existed in the political, not the legal realm. I'm going to intersperse here with a reference to a 2022 opinion of the United Nations Human Rights Commission. The Torres Strait Islanders petitioned the UN Human Rights Commission based on alleged breaches of their rights under the International Covenant of Civil and Political Rights, because those islands are very susceptible to changes in sea levels and have already seen loss of land and loss of areas of cultural significance due to sea level rises. The UNHRC, based on this rights-based approach, determined that there were breaches of state duty, and accordingly the rights vested in those people led to corresponding duties on the state. Now, in contrast, the representatives of the Torres Strait Islander peoples recently took proceedings claiming an alleged duty of care in circumstances where they said their homeland was directly and immediately threatened by rising sea levels. The case, known as Pabai, alleged that the Commonwealth owed the Torres Strait Islander peoples and future generations of Torres Strait Islanders a common law duty of care to protect them and their culture from the harmful effects of climate change. Again, climate change and the risks it presented, including the particular vulnerability of the Torres Strait Islander people, was not in doubt. But again, the court rejected the claimed duty of care. The basis again was that the content of the claimed duty, that is what Australia should do in response to climate change, was a matter of core or high government policy, which was in the political arena and not a matter for judicial decision. Now, these doctrinal limits, as they currently have been understood to apply, I should note that neither of these cases have yet made the highest appellate level to the court of which I am a member, can be contrasted with the international approach. I've already referred to the Human Rights Commission, but of course I must refer to the recently published opinion of the International Court of Justice, which focused on international obligations to what they described as the climate system, so that a failure of compliance, that is what they described as an internationally wrongful act, which is attributable to a state, can give rise to legal remedy. In this conception, attribution to a state does not depend on an act or omission of a state being a material cause of harm. What is required is a sufficiently direct and certain causal nexus between the act or omission and the protection of the overall climate system, irrespective of whether there's other harm, apart from harm to the climate system itself, and irrespective of the concurrence of other causes to that harm to the climate system. Now, what's really interesting here is the objectification of the climate system as a thing in and of itself capable of protection in law, irrespective of a particular impact on a group, a people's, a nation. So this thing, the climate system, becomes capable of legal protection in an international law. Now, this conception, of course, is quite different from common law orthodoxy. But in Australia, as I've said, the common law is always subject to statutory modification and development. And of course, in a federal system where we have one common law of Australia, there are many moving parts that go to make up the whole. In Australia, there has been a robust legislative and regulatory response, which is creating a new legal framework to which the common law will have to, in time, adapt. As one example, from 1 January 2025, new legislation requires certain businesses to comply with mandatory climate-related disclosure obligations, and they require this on the basis of a climate resilience model of the business on two bases. One, a 1.5 degrees Celsius rise above temperature rise above pre-industrial levels, and the other a 2 degree Celsius rise. So what we have is a circumstance in which, as legislation and regulatory responses to climate change increase, as they undoubtedly will, the common law will evolve in order to deal with those changes. It has done so in the past, and I have no doubt it will be capable of doing so in the future. Thank you.
Thank you very much. إذن شكرا للسيدة جين جاكوت التي عرضت علينا التجربة الأسترالية في مجال مكافحة تغير المناخ، وأعتقد أن الفكرة الرئيسية التي ركزت عليها هي الجوانب الإجرائية التي ما زالت تحول دون تسهيل التقاضي المناخي. كما قلت في الكلمة الافتتاحية أن ظاهرة التغير المناخي ظاهرة عالمية ليست خاصة بدولة أو بقارة معينة، وإنما هي ظاهرة متنقلة. فإن عندما نبحث عن الأسباب سنجد أن هذه الأسباب أسباب عالمية، وكذلك النتائج ستكون نتائج عالمية، وبالتالي هناك كذلك صعوبات في تحديد العلاقة بين المخطئ وبين الفعل الضار وبين العلاقة السببية بينهما. إذن من خلال المناقشة ربما سنحاول أن نبحث أكثر في هذه التجربة الأسترالية. المداخلة الثانية هي للسيد جاك ميزار من فرنسا. السيد جاك ميزار is a French lawyer and politician of the Radical Party of the Left, who has been serving as a member of the Constitutional Council since 2019. He previously served as a Minister of Agriculture and Food in 2017 and a Minister of Territorial Cohesion from 2017 to 2018. A member of the Radical Party of the Left, PRG, he was a senator representing the Cantal Department from 2008 to 2017 and again from 2018 until 2019. فليتفضل السيد جاك مازو مشكورا لتقديم مداخلته ومساهمته في هذا الموضوع.
Merci, Chief Justice Maya, merci de votre accueil et en premier lieu d'être ce que vous êtes, votre histoire personnelle, celle de l'Afrique du Sud, démontre qu'il ne faut jamais désespérer de l'humanité. Vous représentez l'espoir. En m'adressant à vous sur un sujet aussi fondamental que la justice climatique, je me dois d'exprimer une pensée reconnaissante à Laurent Fabius, président du Conseil constitutionnel jusqu'au mois de mars, qui fut le président efficace de la COP 21 et le négociateur de l'accord de Paris sur le climat. Convaincu que la crise climatique devenait une problématique majeure pour l'humanité aujourd'hui et pour les générations futures, il savait que le droit international et national allait devoir donner des réponses nouvelles à des questions nouvelles. Le réchauffement climatique est une réalité et les études scientifiques sont globalement univoques pour le constater. Les conséquences sont déjà largement perceptibles et impactent la vie quotidienne de nombre d'habitants. Il est illusoire, mesdames, messieurs, dangereux et lourd de responsabilité de faire croire que la construction de murs le long des frontières et de digues le long des océans protégera quelque pays que ce soit durablement. La raison et l'éthique, donc le droit, qui organise les relations entre les hommes, impose d'apporter tout à la fois une vision nationale, une approche régionale, une volonté internationale. Le dialogue des juges y a sa place, parce qu'il ne saurait y avoir de solution égoïste. La loi du plus fort n'a aucun sens pour lutter contre le dérèglement climatique. Comment instaurer une justice climatique lorsque l'on conteste l'existence du réchauffement climatique? Comment aujourd'hui, ici à Johannesburg, ne pas en préambule souligner l'importance de l'avis consultatif rendu le 29 mars 2023 2025 par la Cour internationale de justice. Par la résolution adoptée en mars 2023 par l'Assemblée générale de l'ONU, qui a décidé, conformément à l'article 36 de la Charte des Nations unies, de demander à la Cour internationale de justice un avis consultatif sur deux questions essentielles consacrant l'importance de la justice climatique. Quelles sont en droit international les obligations incombant aux États en ce qui concerne la protection des systèmes climatiques contre les émissions anthropiques de gaz à effet de serre pour les États et pour les générations présentes et futures? Deuxièmement, quelles sont les conséquences juridiques pour les États qui, par leurs actions ou émissions, ont causé des dommages significatifs au système climatique et autres composantes de l'environnement, et ce au préjudice des générations présentes et futures? L'avis rendu le 25 juillet dernier par la Cour internationale de justice a bien des aspects fondateurs. D'abord parce que la Cour internationale s'est déclarée compétente, ensuite par ses dispositions de fond. La Cour internationale est d'avis que les traités relatifs au changement climatique imposent aux États parties des obligations contraignantes relativement à la protection du système climatique et des composantes de l'environnement contre les gaz à effet de serre. Ces obligations concernent tant l'adoption de mesures d'atténuation des émissions de gaz à effet de serre et d'adaptation au changement climatique que l'obligation de coopération et pour les signataires de l'accord de Paris, le respect des objectifs fixés à 1,5 degré centigrade. La Cour internationale est d'avis que le droit international coutumier impose aux États des obligations relatives à la protection du système climatique. Les États ayant l'obligation de prévenir les dommages significatifs à l'environnement, conformément à leurs responsabilités communes, mais différenciées, et à leurs capacités respectives de coopérer de bonne foi à cette obligation. La Cour est d'avis qu'une violation d'une quelconque des obligations précédemment définies constitue, de la part d'un État, un fait internationalement illicite, engageant sa responsabilité, l'État responsable ayant un devoir continu de s'acquitter de l'obligation à laquelle il a été manqué. Cet avis consultatif clair, rationnel, solidement motivé et en même temps très équilibré peut et doit aujourd'hui inspirer la justice climatique et puis-je dire la justice tout court, tant il s'agit de faire face pour l'humanité à une crise existentielle impactant quasiment tous les aspects de la vie de tous nos concitoyens, aujourd'hui et pour les générations futures. En se déclarant compétente, la Cour internationale a consacré le fait que la justice climatique relevait du domaine juridique, ce que la pratique de nos institutions, de nos cours suprêmes, des tribunaux confirme chaque jour davantage. Cela aujourd'hui relève d'une évidence. Comment peut-on sérieusement imaginer que la crise climatique n'aurait point de conséquences sur ce qui doit être l'essence même de la mission de la justice et des institutions, la protection des droits et libertés fondamentales, la dignité de la personne humaine? Comment imaginer que l'état de droit protecteur de ces libertés ne serait point au cœur de la résolution de cette crise, tant les changements climatiques sont graves et profonds, affectant aussi bien les écosystèmes naturels que les populations humaines, de l'élévation du niveau de la mer menaçant des communautés entières et parfois même l'existence d'États, aux phénomènes météorologiques extrêmes, ouragans, sécheresses, incendies, production agricole, jusqu'aux pénuries d'eau et à l'effondrement de la biodiversité. Ce sont la vie et la santé humaine qui sont compromises. La question de l'eau, de sa qualité, de sa ressource est immédiate. Et il est certainement plus efficace, plus juste, de creuser des puits que de construire des barrières. L'homme ne peut vivre sans eau, l'homme ne peut vivre sous l'eau. L'état de droit se doit d'être une colonne vertébrale de la justice climatique parce qu'il s'agit de l'avenir de l'humanité. La question de la migration climatique est posée. Elle sera de cardinale importance dans les prochaines décennies, devenant une priorité politique et provoquant hélas des conflits sur tous les continents. L'action internationale est d'autant plus nécessaire que le changement climatique n'a que faire, je l'ai dit, des frontières, que ce soit par la mer, par la pollution de l'air, par les ouragans. Et nous savons tous que des activités développées dans tel pays peuvent générer des nuisances à court ou long terme dans d'autres pays. En la matière, la coopération, qu'elle soit technique, économique ou juridique, n'est pas simplement un objectif, mais une nécessité impérieuse. Ces évolutions institutionnelles que nous devons faire sont d'autant plus logiques que les citoyens eux-mêmes s'adressent directement et de plus en plus fréquemment aux tribunaux et à des instances comme la Cour européenne des droits de l'homme pour faire valoir leurs droits suite à des préjudices découlant d'événements climatiques ou de désordres environnementaux, et n'hésitent plus à mettre en cause la responsabilité des États pour obtenir réparation, pour obtenir condamnation des États pour insuffisance d'action dans la lutte contre le réchauffement climatique. Cette pression citoyenne sera de plus en plus forte. À l'initiative du président Chirac, la France s'est dotée en 2024 d'une charte de l'environnement, laquelle, par une révision constitutionnelle de 2005, fut introduite dans le bloc de constitutionnalité français. Et l'article 1er de cette charte dispose « Chacun a le droit de vivre dans un environnement équilibré et respectueux de la santé ». Son préambule rappelle que la préservation de l'environnement doit être recherchée au même titre que les autres intérêts fondamentaux de la nation. Cette charte met en exergue plusieurs principes, dont le principe de prévention des atteintes à l'environnement. Et toutes les dispositions de la charte ont une valeur constitutionnelle et s'imposent aux pouvoirs publics et aux autorités administratives dans leurs domaines de compétences respectifs. Notre Conseil constitutionnel à tirer toutes les conséquences de l'extension du domaine de la loi par cette révision de 2005. Et c'est donc au législateur qu'il revient de déterminer les principes fondamentaux et non au domaine réglementaire. Nous avons pu déduire de cette charte un objectif à valeur constitutionnelle de protection de l'environnement, patrimoine commun de l'humanité, pouvant ainsi justifier par exemple des atteintes à la liberté d'entreprendre. De manière générale, toutes les juridictions chargées de l'application de la charte ont tiré les conséquences de son intégration dans le bloc de constitutionnalité, dont le Conseil d'État. Notre Conseil constitutionnel, du fait de l'intégration de la charte dans le bloc de constitutionnalité, fut amené à rendre plusieurs décisions dans des domaines assez variés touchant à l'environnement. J'en ai extrait quelques-unes montrant à la fois la diversité des sujets et la nécessité d'une approche pluridisciplinaire. Nous avons été amenés à juger des questions relatives aux organismes génétiquement modifiés. En 2013, à la transition vers un système énergétique sobre facilitant l'installation des éoliennes et la tarification de l'eau. Nous avons aussi eu à juger une question sur la production et l'utilisation de produits phytopharmaceutiques. En 2022, notre Conseil était saisi du refus de prolongation de concessions minières par rapport aux conséquences sur l'environnement. Nous avons aussi eu à juger l'exception pour les moulins à eau des obligations assurant la continuité écologique des cours d'eau. En 2022, nous avons validé la possibilité d'installer un terminal méthanisé flottant en jugeant que la préservation de l'environnement devait être recherchée au même titre que les autres intérêts fondamentaux de la nation. Je prête une attention toute particulière à la décision rendue en 2023 concernant le stockage en couche géologique profonde des déchets radioactifs. Vous savez que la France a beaucoup privilégié la production d'électricité nucléaire et nous avons inévitablement beaucoup de déchets à traiter, y compris d'ailleurs pour d'autres pays. Et nous avons rendu une décision validant une possibilité de les stocker en couche géologique profonde en retenant toutes les garanties qui étaient apportées pour que ce stockage puisse être réversible, y compris sur des périodes allant jusqu'à une centaine d'années, ce qui n'est pas grand-chose en matière radioactive. Et nous avons surtout visé la protection des générations futures. Cette décision, fondée sur le dernier alinéa du préambule de la Charte de l'environnement, est emblématique de l'évolution de la justice constitutionnelle de notre pays, intégrant pleinement la notion de justice climatique, et nous entrons, mesdames et messieurs, directement dans l'ère du droit des générations futures, à ce que des auteurs synthétisent par la formule « protéger l'avenir de l'avenir ». Bien sûr, cela amènera à allonger le temps du droit, considéré jusqu'alors comme un temps court, et ce parce que nous devons privilégier le premier des droits, celui qui est à la source de tous les autres, le droit à la vie. Aujourd'hui, notre Conseil exerce un contrôle de pleine proportionnalité, et si nous constatons une atteinte à l'environnement, nous l'examinons au regard de l'exigence constitutionnelle, par exemple d'ordre public, et le cas échéant, cela peut expliquer et permettre cette atteinte. Nous avons élevé l'objectif de protection de l'environnement au rang constitutionnel, l'environnement étant défini comme patrimoine commun de l'humanité. Et cela, incontestablement, ouvre la voie à d'autres évolutions jurisprudentielles. L'obligation de vigilance environnementale doit accompagner la réflexion et la prise de décision. Certes, l'intelligence artificielle peut aider à cette réflexion, mais la décision incombera toujours aux acteurs humains, à commencer par les juges, car celui ou ceux qui signent une décision en assumeront toujours la responsabilité. Cette obligation de vigilance environnement qui est tant de la responsabilité des États, des pouvoirs publics, qu'aujourd'hui celle des juges, nous oblige à anticiper les conséquences de nos décisions sur les générations futures. Il ne suffit plus de répondre aux nécessités du présent. Nous devons le faire en évitant au maximum de compromettre l'avenir des générations futures. Ne nous leurrons pas. C'est une vraie révolution, y compris dans l'analyse juridique et dans la motivation de nos décisions. Soyons aussi conscients qu'à la révolution climatique s'ajoute la révolution numérique. Nos concitoyens, par Internet, par les réseaux sociaux, par les télévisions, sont des milliards d'entre eux en prise directe au quotidien avec le dérèglement climatique quand ils ne le subissent pas personnellement. Ils n'hésitent plus à saisir directement la justice et à mettre en jeu la responsabilité des États, des gouvernants, des collectivités locales et régionales. Il est clair que cette judiciarisation des questions climatiques progresse considérablement et le fera davantage dans les prochaines années. Et le droit ne peut être un obstacle à la lutte contre le changement climatique. Au contraire, il convient qu'il en soit un instrument diligent, car il est la colonne vertébrale de la société humaine. Le droit a le devoir de ne point ignorer la science, il doit l'intégrer, et nos cours ont tout intérêt à rechercher dans ce domaine, comme tant d'autres, et le plus en amont possible, la compétence des experts scientifiques, leurs avis, voire leurs divergences. Soyons lucides, jamais dans ce que l'on appelle la période historique, les évolutions technologiques et sociologiques ne furent aussi rapides. Les connaissances bouleversées, l'histoire de l'humanité accélère comme jamais, et il n'est pas étonnant que nos institutions aient des difficultés à suivre une évolution accélérée et encore plus de difficultés à les anticiper. Mais il est des principes fondamentaux intangibles, fondateurs de ce que doit être la société humaine et les relations entre les hommes. Je pense à la Déclaration universelle des droits de l'homme, aux mots qui nous sont chers, liberté, égalité, fraternité. Ces principes sont parfaitement utilisables au service de ce que doit être une justice climatique, consciente de la réalité de la situation, appuyée sur la connaissance scientifique et transparente. Dans la ligne de l'avis de la Cour internationale de la justice, il est évident que cette question impose la coopération internationale, parfois la cogestion, et qu'elle se devra d'être pluridisciplinaire, appuyée sur toutes les disciplines du droit, impactant tous les secteurs de l'activité humaine. Le droit n'a de sens que s'il est au service de l'humain. Si l'intelligence artificielle ne peut distinguer le bien du mal, la justice, elle, le doit. Chers collègues, mesdames et messieurs, si je puis, après plus de 60 années de pratique du droit et de la vie publique, émettre très modestement, avec humilité, un souhait, c'est celui d'une justice climatique équilibrée, sachant peser sereinement le contrôle de proportionnalité, sachant ne rien cacher et sachant ne rien exagérer. Une justice alliant fusionnellement autorité et bienveillance, confiante en l'avenir de l'humanité, refusant la désespérance. Mesdames et messieurs, quelle plus belle mission pour le droit que de préserver la vie. Merci.
إذن شكرا للسيد جاك ميزار الذي حاول أن يعطينا التجربة الفرنسية في مواجهة تغير المناخ، ولعل أبرز مؤشر للاهتمام في الجانب الفرنسي بالمناخ هو إدراج ميثاق البيئة في الدستور منذ 2005، وهو بدأ مداخلته بالتساؤل عما هي الالتزامات الدولية وكيف يمكننا حماية شعوبنا من تداعيات التغيرات المناخية، وما هي التداعيات على الدول التي ساهمت في تصرفاتها على التأثير على البيئة. هذا التصرف سيعرض حاضرنا ومستقبلنا. وما هي الأدوار التي يجب أن تقوم بها الدول التي تساهم في الانبعاثات الحرارية. وهذا يدعو إلى الحاجة إلى التعاون والوفاء بالالتزامات. إذن هناك تجربة فرنسية في مجال الاعتراف بضرورة التعاون الدولي لتقليل من آثار المناخ، هذه الآثار التي لا تكاد أن تنجو منها دولة أو قارة معينة. هذا فيما يخص هذه المداخلة، كما تطرق إلى أفكار مهمة كثيرة في هذه المداخلة القيمة. المداخلة الثالثة هي للسيد أرسول ساني من أندونيسيا. السيد أرسول ساني stepped into the role of constitutional justice in the Constitutional Court of Indonesia in 2024. He was chosen as nominated by the House of Representatives of the Republic of Indonesia. Before being elected as a member of the People's Representative Council of the Republic of Indonesia in 2014, he was a copyright law practitioner, arbitrator, and executive at a multinational foreign investment company. Arsul has also been deeply involved in community and professional organizations. Throughout his tenure as a member of the People's Representative Council between 2014 and 2023, Arsul received numerous awards. Arsul's passion for writing has resulted in 3 books on law, legal enforcement, and the relationship between Islam and the state, along with numerous articles. فليتفضل مشكورا لإلقاء مداخلته في هذا الموضوع، وله 20 دقيقة، فليتفضل مشكورا.
Chief Justice Mandisa Maya, Chief Justices and Justices of Constitutional Court and Supreme Court participating in this Judiciary Summit, Mr. Chairman, distinguished panelists and participants, good morning. First of all, on behalf of the Constitutional Court of the Republic of Indonesia, I would like to express our thanks and appreciation to Chief Justice Maya, Deputy Chief Justice Lambo, all justices and staff of the Constitutional Court, Republic of South Africa, for warm greeting and hospitalities extended to us and all participants attending this Judiciary Summit. Please allow me to spare some perspective on the topic of this session. One of the most pressing environmental issues attracting global attention is climate change. In general terms, climate change refers to long-term alteration in global climate pattern, particularly temperature, precipitation, and other weather conditions on Earth. The impact of climate change includes global temperature rise, global warming, that generate many bad situations such as rising sea level and severe and extreme weather pattern, causing floods, drought, storm, and heat wave, food and water crisis resulting from ecosystem change, and so on. The Intergovernmental Panel on Climate Change, IPCC, 2023 report concluded that the impact of climate change are inevitable and therefore simultaneous and profound mitigation adaptation effort, both in the present and in the future, are no longer optional but imperative. The IPCC Sixth Assessment Report 2023 underscored that climate change is closely associated with inequalities between nations, region, genders, and age group. Therefore, vulnerable and marginalized are expected to suffer disproportionately compared to wealthier group with better economic condition and access to resources. Indonesia has experienced the direct effect of climate change. Global warming manifests in the increasing trend of temperature and relative humidity in our country. Climate change is also reflected in rainfall variability and the growing frequency of extreme weather and climate events. As the world's largest archipelagic state, Indonesia faces significant threat from rising sea level, with hundreds of islands at risk of submersion in the coming decade. Coastal communities have already been forced to relocate due to inundation, rising concern of an increase in the so-called climate refugees. The Indonesian Constitution provides explicit recognition of environmental protection as a constitutional guarantee for sustainability of the nation's natural environment. This enshrined in some article of the Constitution. Indonesia has also enacted several statutes and regulations, including law on environmental protection and management, law ratifying the Paris Agreement, law ratifying the UN Framework Convention on Climate Change. While these frameworks are significant for us, but we are aware that climate change requires global cooperation and collective responsibility. In addressing both the causes and consequences of climate change, the concept of climate justice has emerged to integrate consideration of fairness and right. According to IPCC, climate justice adopts a right-based approach, emphasizing equitable sharing of the burden and benefit of climate action, while safeguarding the right of vulnerable communities. The root of climate justice can be traced to the 1992 UNFCCC. It introduced the principle of common but differentiated responsibilities and respective capabilities, CBDRRC. This principle acknowledges the disproportionate responsibilities and benefit arising from climate change, given the historical emission of developed nations compared to developing one. Climate justice will not achieve both globally and domestically when the burden and benefit of mitigation and adaptation are distributed unfairly, and when vulnerable groups within states bear disproportionate impact. In this context, 4 principles underpin climate justice, namely recognitional justice, which acknowledging the disproportionate impact of climate change on vulnerable groups; procedural justice, which ensuring inclusive participation, especially of vulnerable stakeholders in climate decision making; distributive justice, which ensure fair allocation of burden and benefit across individual, nation, and generation; and restorative justice, which addressing harm suffered by individual, communities, and ecosystem. At the global level, at least 3 particularly urgent issues demand attention. First, common but differentiated responsibility and respective capability, CBDRRC. Second, loss and damage. Third, fixed maritime boundaries, FMB. This challenge highlights the essential role of cross-border judicial collaboration in advancing climate justice. Courts play a pivotal role in resolving disputes, including those involving environmental issues. Judicial decisions not only ensure justice, but also uphold legal certainty, and serve broader societal benefit. To adjudicate environmental dispute effectively, judges must be equipped with deep knowledge of environmental principle and sustainable development concept. Since climate change transcends national boundaries, court should also consider comparative justice from foreign jurisdiction. Even not binding foreign case law can offer valuable perspective for judges in saving domestic. And in this context, I can tell my colleague from the Constitutional Court, Republic of South Africa, that one of your judgment, Dr. for life cases, is very famous in Indonesia. It is quite often used by petitioner and expert to establish argument when challenging Parliament on meaningful public participation process in legislation process. Thanks to South Africa, actually, from us. In Indonesia, the Constitutional Court frequently draws on comparative judicial practices to enrich its reasoning. Through judicial review, the court has annulled or interpreted statute inconsistent with the constitutional right to a healthy environment, thus reinforcing sustainability principle, human rights, and alignment of government policies with environmental protection. Although not always directly on climate change, several of our Constitutional Court decisions illustrate a consistent commitment to environmental protection and sustainable development. Our cases demonstrate, our judgment demonstrate our court role in embedding environmental sustainability into constitutional interpretation. Indonesia Constitutional Court served as the permanent secretariat for planning and coordination of the Association of Asian Constitutional Court and equivalent institution, AACC, a forum of 21 member states facilitating dialogue and experience sharing amongst the judges. Similar association we know exists in other regions, such as Conference of Constitutional Jurisdiction of Africa, CCGA, Ibero-American Conference of Constitutional Justice, CIGC, Conference of European Constitutional Court, CECC, and Association of Francophone Constitutional Court, ACCPUF. Climate justice can be integrated into the agenda of this association. Judges may exchange landmark ruling for comparative insight, engage in training program, and conduct dialogue and on transboundary issues to identify mutually beneficial solutions. At the regional level, cooperation is already evident. For instance, in the MOU between AECC Asia and CCGA Africa. At the global level, the forthcoming 6th Congress of the World Conference on Constitutional Justice, WCCG, to be held in Madrid on 28-30 October 2025, under the theme Human Rights of Future Generations, provide another opportunity to integrate climate change justice into judicial discourse. In conclusion, climate change is not a local issue, but a global crisis whose consequences extend beyond current generation to future one. Addressing it requires not only national action, but also cross-border judicial collaboration. While governments have long spearheaded international cooperation, it is time for judiciaries to play a more active role. Court can safeguard the implementation of international climate commitment, ensure proportional contribution from state, and strengthen the voice of climate justice. Judicial collaboration is therefore indispensable. The J20 J20 summit in Johannesburg may serve as a historic milestone for fostering global judicial cooperation and advancing climate change justice for the benefit of present and future generations. Thank you for giving us opportunity, and I stop here and I donate about 7 minutes to the next speaker. Thank you.
إذن شكرا للسيد أرسل ساني الذي تحدث عن التجربة الأندونيسية وركز في الأخير على أن المناخ هو أزمة عالمية يتعدى الأجيال الحالية ويتطلع إلى الأجيال المستقبلية، ولا يعتبر عملا وطنيا ولكن يتطلب تعاونا دوليا عابرا للحدود. واختتم مداخلته بأنه قد حان الوقت لتلعب السلطات القضائية أكثر نشاطا حماية للالتزامات المناخية. والتعاون القضائي كما جاء في آخر مداخلته لا مفر منه، وقد تكون هذه القمة قمة J20 معلما لتعزيز العدالة المناخية. وبالتالي فالمتدخلين الثلاثة ركزوا على أن لا مفر من التعاون القضائي، وأن الأجيال الحالية والأجيال المستقبلية كلها معنية ببيئة سليمة ونظيفة ومناخ نظيف. المداخلة الأخيرة في هذا الموضوع المتعلق بالعدالة المناخية والتعاون القضائي هي للسيدة لوتشيا ريبيرو. Lucia Ribeiro was appointed President of the Constitutional Council of Mozambique in 2019, being the first woman to chair the institution. So we have, I think, 3 women in the Constitutional Court in Africa till now. Assistant Professor of the Law School, Eduardo Mondian University. She has also served as a Dean of the Faculty of Law, member of the African and International Associations of Constitutional Law, collaborated at the Legal and Judicial Training Center, lawyer and president of the Jurisdictional Council of the respective Bar Association, legal advisor of the Minister of Public Works and Housing, activist and founding member of the association related to the development of women in law. إذن من خلال السيدة لوتشيا روبرتو سنرى التجربة إفريقية في مجال تغير المناخ، فلتتفضل مشكورة.
Bom dia. Sua Excelência Mandisa Maya, Presidente do Tribunal Constitucional da África do Sul, respeitada Chief Justice, Suas Excelências Presidentes dos Tribunais Constitucionais e Supremos aqui presentes, distintos participantes, permitam-me que diga todo o protocolo observado. As minhas primeiras palavras, como não poderia deixar de ser, são de agradecimento e de felicitações. Agradecimento pelo honroso convite que foi efetuado, que nos foi dirigido pessoalmente e como Conselho Constitucional de Moçambique, pela honra de estar aqui neste pódio e falar para tão distintos participantes. Também felicitamos a organização deste evento, o J20, e agradecemos ao mesmo tempo a hospitalidade que nos é dispensada desde a nossa chegada. O meu tema é o papel do sistema de justiça na salvaguarda da justiça climática, com foco para Moçambique. Esta comunicação explora o papel do sistema de justiça na salvaguarda da justiça climática, com ênfase particular para Moçambique, país contribuinte mínimo para as emissões de gases de efeito de estufa. As mudanças climáticas representam uma ameaça significativa à estabilidade e ao desenvolvimento global, havendo nações vulneráveis como Moçambique que sofrem os efeitos adversos destas consequências gravosas em diversos aspectos humanitários. O sistema de justiça é essencial para a implementação efetiva dos compromissos climáticos, resolução de disputas e garantia de que as vozes de todos os membros da sociedade sejam ouvidas nas negociações climáticas. Tendo em conta o papel dos tribunais na sociedade, qual deverá ser o papel no âmbito da mitigação das mudanças climáticas? Nós falaremos um bocado do quadro legal moçambicano, de como Moçambique lida com as questões ambientais, da proteção dos grupos vulneráveis e o papel do sistema de justiça na justiça climática. Relativamente ao quadro legal, é importante referir que a primeira Constituição da República Popular de Moçambique de 1975 não fazia qualquer alusão direta ao ambiente. Mas já a Constituição da República de 1990, a segunda, contempla normas relativas ao ambiente que definem, respectivamente, o direito fundamental do cidadão moçambicano de viver num ambiente equilibrado e a responsabilidade do Estado de garantir o equilíbrio ecológico e a preservação do ambiente. A Constituição atual de 2004 fortalece o compromisso nacional com a justiça climática, estabelecendo que todo cidadão tem o direito de viver num ambiente equilibrado e o dever de o defender. Esta disposição significa que todo cidadão tem o direito fundamental a um meio ambiente que sirva, que seja livre de poluição, com condições salubres e, ao mesmo tempo, a responsabilidade de ativamente proteger e preservar esse ambiente para as gerações futuras. Isso implica que o direito e o dever estão interligados e que a preservação ambiental é uma obrigação, tanto do Estado quanto de todos os indivíduos, e não apenas de governos ou de quem causa a poluição. E é por isso que a educação e a consciencialização pública são elementos fundamentais para a construção de um círculo mais amplo de cidadãos informados sobre o ambiente e sobre as mudanças climáticas. É importante referir que o Estado é responsável por promover iniciativas para garantir o equilíbrio ecológico, a conservação e a preservação do ambiente, visando a melhoria da qualidade de vida dos cidadãos, bem como o desenvolvimento sustentável. O Estado deve adotar políticas visando prevenir e controlar a poluição e a erosão, integrar os objetivos ambientais nas políticas setoriais, promover a integração dos valores do ambiente nas políticas e programas educacionais, garantir o aproveitamento racional dos recursos naturais com salvaguarda da sua capacidade de renovação, da estabilidade ecológica e dos direitos das gerações vindouras. Promover o ordenamento do território com vista a uma correta localização das atividades e a um desenvolvimento socioeconômico equilibrado. A incorporação deste direito constitucional na governação climática confere aos cidadãos um quadro legal para a implementação da justiça climática e a possibilidade de responsabilização dos agentes incumpridores dos compromissos climáticos. Para além dos instrumentos internacionais ratificados, podemos apontar a Lei do Ambiente, de 1997. Esta lei estabelece um quadro abrangente para a proteção ambiental, garantindo que considerações climáticas sejam integradas nas políticas nacionais. Como se pode depreender, pelo tempo de sua vigência, esta lei já está um pouco desajustada dos desafios atuais e dos compromissos ambientais de hoje, aliada à questão das mudanças climáticas, que hoje são maiores do que há 20 anos, à altura em que ela foi aprovada. Temos também a Estratégia Nacional de Adaptação e Mitigação de Mudanças Climáticas, que foi aprovada em 2013. Esta estratégia delineia ações para melhorar a resiliência e promover a mitigação, refletindo o foco na Convenção sobre as Mudanças Climáticas, na adaptação e no desenvolvimento sustentável. Temos também as iniciativas de infraestruturas resilientes ao clima, que foi aprovada em 2022, onde se pretende construir escolas resilientes ao clima e demais infraestrutura. Esta política visa aumentar a resiliência nos serviços essenciais, demonstrando o compromisso de Moçambique com a adaptação climática. Podemos também dizer que as mudanças climáticas são tratadas de duas maneiras principais, nomeadamente através da sua mitigação, o tratamento das causas e o seu controle, por um lado, e a adaptação, que é tratar das consequências, por outro. A combinação dos dois produz um efeito amortecedor que é tecnicamente designado por resiliência climática. Na mitigação, as ações principais são a redução das emissões de gases de efeito de estufa, aquelas que contribuem para o aumento do aquecimento global, e para Moçambique, o maior centro de emissões até ao momento são as florestas, por conta do desmatamento e degradação causada pelo homem. A nova Lei de Florestas, aprovada em 2023, promove a conservação e o uso sustentável das florestas como recurso econômico e ambiental. Esta lei é implacável relativamente às infrações. Os tribunais administrativos têm também um campo de atuação no que concerne à observação da legalidade, na implementação dessas medidas e, se necessário, aconselhar a sua melhoria, caso se mostre necessário. Na adaptação, o país é chamado a fazer o seu melhor, pois, embora seja contribuinte mínimo na emissão de gases de efeito de estufa, ele é um dos mais afetados pelas mudanças climáticas, dada a sua localização geográfica, devendo, para se defender, optar por um mecanismo de adaptação bastante robusto. Relativamente à proteção de grupos vulneráveis, o sistema de justiça desempenha um papel crucial na proteção dos direitos das populações vulneráveis, assegurando que suas necessidades sejam consideradas nas políticas e ações ambientais. Este aspecto é particularmente relevante para Moçambique, onde as comunidades enfrentam eventos climáticos extremos como ciclones, cheias, inundações e secas. É importante em muitas regiões do mundo, e Moçambique não é exceção, o esgotamento dos recursos naturais, a desertificação e degradação dos solos, a escassez de água, a perda da biodiversidade, a subida do nível das águas do mar, a acidificação dos oceanos e outros efeitos que estão a afetar gravemente as zonas costeiras, como é o caso da cidade da Beira, no centro de Moçambique. E aqui nos lembramos do ciclone Idai, que provocou centenas de mortos e a devastação inimagináveis de infraestruturas, para além dos ciclones, tempestades tropicais, cheias e demais consequências. É reconhecido que os impactos ambientais são bastante mais notórios nos países em desenvolvimento e, sobretudo, nas populações mais pobres e mais dependentes do setor primário, como a agricultura, a pastorícia, a floresta e a pesca. Dentro dos mais pobres, é ainda de salientar que as mulheres e as crianças são as mais vulneráveis. São elas que, nas zonas rurais e não só, são as principais responsáveis pela maior parte do trabalho agrícola, pela recolha de água e de combustível lenhoso para a sobrevivência diária ou segurança alimentar das suas famílias. Convém fazer notar que, no âmbito da consulta comunitária, é obrigatório que no processo seja considerada a participação das comunidades locais, das mulheres, jovens e grupos vulneráveis. As comunidades altamente afetadas pela degradação ambiental também tendem a enfrentar outros problemas sociais, tais como as altas taxas de pobreza, problemas de saúde, desalojamentos e migrações em massa. Qual será, então, o papel do sistema de justiça na justiça climática? A Convenção sobre as Mudanças Climáticas estabelece um quadro legal vinculativo que exige que as partes tomem medidas contra as mudanças climáticas. Este quadro é fundamental, entre outros, no princípio da responsabilidade comuns nas mais diferenciadas, garantindo que as nações desenvolvidas apoiem os países em desenvolvimento na abordagem dos desafios climáticos. A educação e a consciencialização pública são elementos fundamentais para a construção de um círculo mais amplo de cidadãos informados sobre a Convenção sobre as Mudanças Climáticas. Neste contexto, surge um movimento crescente no campo jurídico, conhecido como justiça climática, que visa garantir que a justiça social e a proteção ambiental sejam levadas em consideração no enfrentamento das mudanças climáticas. A justiça climática, como conceito, envolve a responsabilização das partes que contribuem para a deterioração do meio ambiente, incluindo governos e empresas, além de buscar a reparação de danos causados e a mitigação dos impactos ambientais. Diante das mudanças climáticas, o Poder Judicial tem sido chamado a adaptar e atuar de maneira proativa na proteção do meio ambiente e das comunidades vulneráveis, contribuindo com as suas decisões para uma resposta mais eficaz às demandas ambientais. Considerando o papel educacional constitucionalmente consagrado aos tribunais, concretamente no artigo 212, o sistema de justiça deve promover a mudança comportamental dos cidadãos através da divulgação do direito e da consciencialização da sociedade sobre a importância do cumprimento da lei, promovendo e respeitando pela justiça e o funcionamento adequado do sistema judicial e também na promoção da cultura da legalidade. Os tribunais, ao aplicarem a lei, servem como modelos de conduta e incentivam a prática de atos conformes com a ordem jurídica, de modo a serem agentes ativos na construção da resiliência climática. Estes contribuem para a fortificação das instituições, combate à corrupção e responsabilização dos infratores, pois as mudanças climáticas são causadas pelo homem. Para que a justiça climática seja efetiva, é necessário que o pessoal do setor de justiça não apenas reconheça a urgência da crise ambiental, mas também possua um conhecimento necessário para lidar com litígios complexos que envolvam múltiplos agentes e contextos multidisciplinares. Por isso, se afigura importante a formação em redução dos riscos de desastres para um futuro sustentável e resiliente. Cursos de capacitação têm sido levados a cabo, que são cursos conjuntos, preparando todos os envolvidos para a interpretação de conceitos e aspectos técnicos de manejo florestal, aplicando-os nos autos dos processos crime relacionados com as infrações e crimes. A Procuradoria-Geral da República, defensora da legalidade e do interesse público, assume o seu vital papel na defesa dos interesses ambientais, concretamente o exercício da ação penal, assegurando a aplicação das respectivas sanções. A atuação dos tribunais na interpretação e aplicação das leis ambientais é crucial para a efetividade das políticas de mitigação, devendo usar a sua ação como meio de pressão aos governos, empresas e demais pessoas coletivas para adotarem políticas mais sustentáveis, de modo a promoverem a redução das emissões dos gases de efeito de estufa. Além disso, os litígios climáticos podem servir como meio para a consciencialização pública sobre a urgência das questões climáticas e o impacto das ações humanas no meio ambiente, permitindo que cidadãos e organizações não governamentais participem ativamente do processo de busca por soluções justas e eficazes. Um exemplo da intervenção do Poder Judicial, podemos apontar um caso grave de danos ao ambiente e à saúde da população causados por uma empresa mineradora na província de Tete. Esta mineradora foi intimada a abster-se de poluir, entretanto recorreu da decisão e não está a cumprir com o decidido pelo Tribunal de Primeira Instância. Aguarda-se a decisão do recurso e já decorre um tempo significativo, mais de 5 anos sem resposta, e os danos ao ambiente continuam. Daí que a eficácia das normas ambientais dependa da capacidade dos sistemas judiciais em garantir a sua implementação e em julgar com celeridade as demandas relacionadas à proteção ambiental e aos danos provocados pelas mudanças e o que contribuirá para a consolidação do quadro legal. Lembrar que a recente jurisprudência do Tribunal Internacional da Justiça sobre casos relacionados com o clima ressalta as obrigações legais dos Estados em proteger as populações vulneráveis dos danos climáticos. Portanto, os Estados têm uma responsabilidade legal de mitigar os impactos das mudanças climáticas, alinhando-se à ênfase da Convenção das Nações Unidas sobre as Mudanças Climáticas. Termino enfatizando que, de facto, o sistema de justiça é fundamental para a salvaguarda da justiça climática à luz da Convenção Quadro das Nações Unidas sobre as Mudanças Climáticas, particularmente para as nações vulneráveis como Moçambique, e que também o sistema de justiça promove a mudança comportamental de todos os cidadãos face aos desafios impostos pelas mudanças climáticas. Pela atenção dispensada, o meu muito obrigado.
إذن شكرا للقاضية لوتشا ريبيرو، والتي استطاعت أن تنقل لنا تجربة دولة إفريقية هي من الدول المتأثرة بتغير المناخ، ولكن المفارقة أن هذه الدولة المتأثرة بشكل كبير بتغير المناخ هي دولة تعطينا نموذج في الجهود المبذولة لحماية المناخ، وقد تطرقت إلى التطور الذي عرفه القانون الدستوري في الموزمبيق، حيث انتقل من عدم الاعتراف بالحق في بيئة سليمة إلى الاعتراف بالحق في بيئة سليمة وبواجب الدولة في حماية البيئة، واعتبر ذلك التزام على الدولة وعلى الأفراد. وفيما يخص الجهود التي تطرقت إليها هو الاعتماد على التثقيف والوعي الشعبي الذي له دور هام في التوعية في مسائل تغير المناخ، وأن الدولة مسؤولة على تعزيز المبادرات للحفاظ على البيئة لتحسين جودة الحياة. وذكرت لنا للأسف أن هناك مناطق في الموزمبيق تعاني من آثار المناخ، والفئات الهشة هي الأكثر تضرراً من تغير المناخ، خاصة النساء والأطفال. كذلك ذكرت المجهودات التي تبذلها الموزمبيق فيما يخص محاولة تكيف وسائل النقل مع تغير المناخ للتقليل من الانبعاثات الحرارية، والدور الذي يلعبه القضاء في منع المخالفين للتأثير على البيئة من خلال تطبيق مبدأ الملوث يدفع. ثم تكلمت عن الآثار السلبية لتغير المناخ في الموزمبيق ما يمس الوسائل الحيوية بالنسبة للمواطنين كالماء وارتفاع مستوى سطح البحر وتأثر التربة ودمار البيئة التحتية، إضافة إلى الأعاصير والفيضانات. وتختتم مداخلتها بالدعوة إلى ضرورة وجود تعاون وتكاثف لمواجهة كل هذه الآثار البيئية. طبعا قبل أن ننتقل إلى حصة الأسئلة والأجوبة، دعوني أستفيد من 3 دقائق التي تركها زميلنا من أندونيسيا لأؤكد كذلك التجربة الجزائرية فيما يخص تغير المناخ. باختصار في جملة واحدة مفيدة، الجزائر تعطي اهتمام كبير لتغير المناخ على جميع المستويات، سواء على المستوى السياسي أو على المستوى التشريعي أو على المستوى الدستوري أو على المستوى الشعبي أو على المستوى الدولي. فعلى المستوى السياسي في برنامج رئيس الجمهورية للانتخابات الرئاسية لسنة 2019 هناك 54 التزام. الالتزام رقم 33 هو متعلق بضمان ضرورات التنمية مع مراعاة متطلبات البيئة السليمة. الدستور يعترف صراحة بحق المواطن في بيئة سليمة وصحية وعلى التزام الدولة بالحفاظ على البيئة. سنة 2003 صدر القانون المتعلق بحماية البيئة في إطار التنمية المستدامة. على المستوى الشعبي في ديباجة الدستور الجزائري الحالي اللي هو دستور 2020 هناك فقرة صريحة تقول أن الشعب الجزائري من خلال هذا الدستور فإنه يلتزم بالحفاظ على البيئة ومكافحة آثار المناخ وحماية حقوق الأجيال القادمة. أما على المستوى الدولي فالجزائر انضمت إلى مختلف الاتفاقيات الدولية المتعلقة بحماية البيئة ومواجهة آثار المناخ. إذن هذا كل ما تناولناه في هذه الجلسة من خلال المداخلات الأربعة. الآن لدينا 25 دقيقة لحصة الأسئلة والأجوبة. إذا كانت هناك أسئلة فعلى السائل أن يقدم نفسه ويقدم الجهة التي ينتمي إليها، وإذا كان ممكن كذلك يحدد الشخص أو المتدخل الموجه له السؤال. إذن نبدأ على اليسار. تفضل أخي.
Good morning, everyone. Guilherme Canella from UNESCO. I have 2 quick observations and a question related to these observations. First, very glad that Justice Mezad referred to the decision of the International Court of Justice. And here, the 2 observations. I would strongly recommend for those that are not aware that the Inter-American Court of Human Rights took a similar decision, a consultative opinion this year on climate change and human rights, and it's a very, very detailed consultative opinion by the judges of the Inter-American Court of Human Rights, with lots of details very much related to the key questions you discussed during this. The second observation is that Principle 10 of Rio 1992 puts these two issues together, the access of justice and the access of information about environmental issues. And this year, the United Nations is dedicating the International Day on Access to Information to the access to environmental information, which is a critical topic, particularly to counter disinformation on climate change. But then my question related to this is how much your courts actually benefit from a consultative opinion like the one issued by the International Court of Justice or the one issued by the Inter-American Court of Human Rights. Thank you.
شكرا جزيلا على السؤال السيد مازو. ملاحظة توجد إليك، هل ممكن فيه إجابة أو إضافة؟
Oui, la décision de la Cour internationale de justice, nous considérons qu'elle est extrêmement importante puisque forcément elle va impacter la réflexion de nos différentes cours constitutionnelles. Il est des sujets concernant l'environnement qui sont bien évidemment transfrontaliers, c'est-à-dire que toutes les questions de pollution, toutes les questions concernant la préservation de la santé. J'ai pris un exemple concernant les produits phytosanitaires où notre Conseil constitutionnel a considéré que la législation devait interdire l'exportation de produits considérés en Europe comme dangereux, donc il était illicite que nos industriels puissent exporter des produits dangereux en dehors de l'Union européenne, parce qu'il est de notre responsabilité de préserver l'environnement de l'ensemble des citoyens de la communauté internationale. Et si nos cours, nos États ne l'intègrent pas assez rapidement, je pense que beaucoup de nos concitoyens, beaucoup d'ailleurs d'organisations non gouvernementales ont intégré cela. Et c'est pour ça que la réflexion et l'avis consultatif de la Cour internationale de justice est particulièrement important, puisqu'il, certes, ce n'est qu'un avis, mais c'est un avis extrêmement motivé et qui donne un certain nombre de lignes directrices et qui est très clair sur la responsabilité des États et sur la nécessité, y compris par le droit coutumier international, de respecter les traités. Alors, je ne veux pas m'étendre sur la question de ceux qui se retirent des traités, justement, pour ne pas avoir à appliquer les conséquences des signatures précédentes. Mais il est évident que la question environnementale est une question internationale, que la coopération, elle est essentielle et qu'elle le sera de plus en plus. Parce que si les gouvernements, si nos institutions ne le comprennent pas rapidement, je suis convaincu que les peuples, eux, le comprennent aujourd'hui de plus en plus facilement.
شكرا سيد مازو. ممكن أن أضيف فقط فيما يخص الرأي الاستشاري لمحكمة العدل الدولية، يعتبر رأي ذو أهمية كبرى، سواء من حيث الشكل الذي تم التصويت عليه بالإجماع، وكذلك عدد الدول التي شاركت ببياناتها في هذه القضية التي وصلت إلى أكثر من 91 دولة بالإضافة إلى 11 منظمة. وبهذا الرأي الاستشاري رغم أنه غير ملزم ولكنه يؤكد على أن الدول مسؤولة مسؤولية قانونية وليست مسؤولية سياسية، وهذه المسؤولية تقوم على أساس الاتفاقيات الدولية التي انضمت إليها الدول، ثانيا على القانون الدولي العرفي، وكذلك على القانون الدولي لحقوق الإنسان، لأن كل الآثار المترتبة عن تغير المناخ هي تمس بحق الإنسان، وأقدس حق للإنسان هو الحق في الحياة. وبالتالي هذا الرأي الاستشاري سيفتح المجال أمام رفع قدرات المحاكم الوطنية والإقليمية، وكذلك يفتح المجال أمام التعاون الدولي. ورغم ذلك حتى قبل هذا الرأي الاستشاري كانت هناك خطوات مهمة لكثير من المحاكم، سواء المحاكم العادية أو المحاكم الدستورية، لاتخاذ قرارات مهمة فيما يخص التعامل مع آثار تغير المناخ، سواء في ألمانيا أو في هولندا أو حتى هنا في جمهورية جنوب إفريقيا. هل هناك سؤال؟ تفضل.
Good morning. My name is O.S. Sibanda from the University of Limpopo. You know, there was earlier on the discussion around the Australian case in Sharma, and I thought it was quite interesting given, you know, a sort of a different decision that took place in the Netherlands, whereby the government, instead of wanting to reduce carbon emissions to up to 17%, the court said, no, you must go to 25%. But then the question then would be, how far should apex courts, now that we have got Chief Justices here, go in ordering specific adaptation and mitigation, you know, steps without being seen or usurping the powers of the executive? Thank you.
شكرا. هل ممكن إجابة؟
I assume that's working, is it? Yes, thank you. Well, I think my presentation was exposing that in Australia we do have a strict separation, a constitutional separation of powers, just as the judiciary jealously guards the exercise of judicial power. There is a mutual respect there, and the cases to which I referred exposed that the courts see limits on at least exercising common law jurisdiction where there's no particular statutory authority or statutory right or duty in play. Insofar as we were in the realm of the common law, those sorts of calibrations between what is a reasonable or appropriate response based on the litigation to date have clearly been said to be in the political sphere, with the cases saying ultimately the public will decide through the election process whether or not it's satisfied or they're satisfied with the political response of our country to climate change, rather than those issues being seen as appropriate for resolution in the courts. That's at least when we're referring to a common law duty on a government or decision-making body that has to take into account, you know, a multiplicity of factors in order to decide what an appropriate response is. So that's certainly the Australian current experience. What I found interesting about the opinion of the International Court of Justice was this taking of this concept where we've seen that legal personality has been given in other jurisdictions to aspects of the environment, rivers, for example, in New Zealand, which are seen as having particular cultural significance, are vested or have been vested with legal personality, and accordingly they are capable of being protected in law in and of themselves, not in response to human use of them. It seemed to me that the reference to the climate system as a thing in and of itself, a legal thing capable of protection, is a particularly interesting concept. Thank you.
Thank you very much. You, sir?
Hi, good morning. My name is Stephen Chong. I'm from Singapore. I'd like to make an observation. I mean, from the panel discussion, it's clear that climate change litigation offers unique challenges to the courts. And I think that some of the panelists have touched on issues like locus standi, standing to bring a claim, jurisdiction, because the damage is usually cross-border in nature, and thirdly, causation. So I would suggest that the traditional way of dealing with claims, which is rights-based or fault-centric approach, is not suitable to deal with climate change litigation. And let me just share with you a perspective of how I believe that courts cannot deal with this issue alone. You need the support of the legislation. In Singapore, for many years, in the turn of the century, Singapore would suffer annually pollution caused by the burning of the forests in the island of Sumatra, which is Indonesia. And although it's quite a distance away, the haze would affect Singapore, affecting the health of large segments of our country, children, people with respiratory issues. So what a lot of these palm oil plantation owners would do, they would burn the forest in order to plant the palm oil. And that caused significant health issues. So eventually, what the government did was we passed a piece of legislation called the Transboundary Haze Pollution Act. Because many of these palm oil plantation owners have offices in Singapore. So the legislation was targeted not against a country, but against the companies who are responsible for burning these forests. And that if we find that there are certain companies based in Singapore is responsible for burning the forest, then they have corporate liability, which we charge in terms of quite a hefty fine on a per-day basis. And what was the effect of that piece of legislation? The haze disappeared. For the last 10 years, most of the time, we had clean air. We don't have this haze problem coming from Sumatra. So my question to the panel members is, would you agree that without legislative support, the courts will have tremendous difficulty to deal with climate change litigation claims? Thank you.
يطرح السؤال حول دور السلطة التشريعية أو التشريع في المساهمة في تقليل من آثار المناخ. إذا كان هناك إجابة فليتفضل.
Thank you. I agree with the concerns of Justice Joe from Singapore. First, there must be a legislative framework. Yeah. But as we know that legislation is only binding within each country. Yeah. So like Indonesia and Singapore and ASEAN countries, I think needs more than legislation. Yeah. Regional agreement on that. Yeah. Because the problem is not easy. I can describe like that. There is forest fire in our country. It is mentioned in Sumatra Island. It is in the plantation area, which is owned and managed by foreign companies, some from Asian countries too, including from Singapore also. Yeah. And then in Indonesian context, there is regulation to settle that, and also legal and court process on that. But what still becomes challenge is how then, for example, on the compensation issue, can cover not only people in one country, but also people in other country. That is sesuatu yang that we need, yeah, in Asian context, at least Southeast Asia context, yeah, need to compel our respective country to do more than internal legislation, but cross-border legislation. Yeah, this is still our challenge, and maybe if we can also heard from other country about cross-border liability, yeah, applied in legislation of what country, it will be good for us, for Indonesia at least. Thank you.
Thank you, sir. Adam, you can add something?
Yes, in short, I agree. I guess what I was mentioning was that certainly there's a lot of recent legislation in Australia and very robust legislation. And what I see is that ultimately that will set a framework within which climate change litigation can be determined within that legislative framework. I guess the point of what I was saying about the Australian experience is if you're just relying on a common law doctrine without a separate Bill of Rights, you can see that the result in both the cases was identical and the issues were recognised to be political issues, primarily for political action, at least at the national level. The resolution of that is through a legislative framework, and that is what is happening.
Other question? You?
Thank you very much. My name is Leona Theron. I'm from the Constitutional Court of South Africa. Climate change, I think, is a worldwide problem. Does Africa have the resources to devote to climate change right now? Having regard to the fact that we don't produce enough food to feed all our people, and we got so much hunger and starvation. In the lists of priorities for Africa, where should it fall? Thank you.
Muito obrigada. Acho de facto a pergunta pertinente se a África tem esta possibilidade, estes recursos para a mitigação destes efeitos e também esta situação de que de facto a nossa prioridade seja ainda o combate à fome. Eu devo dizer que em Moçambique, pronto, como eu disse, somos um país ainda poluidor mínimo destas mudanças climáticas, mas de facto nós temos um quadro legal que nos permite agir dentro daquilo que são os nossos níveis de poluição e dos danos que são causados às florestas, à caça furtiva e também à pesca. Bom, em termos de recursos não temos muitos assim e daí esta importância de olhar para estas questões das mudanças climáticas a nível global, não é? A nível internacional e correlacionados não apenas ao país específico, ao continente específico, mas olhar para uma visão e uma abordagem mais internacional. Obrigado.
Thank you very much. You, sir? Yes.
It's Owen Rogers from the South African Constitutional Court. I would just make an observation, and obviously if any panel members wish to respond, they can. I was interested by Justice Jagot's reference to working in a common law system and how that might differ from one with a Bill of Rights. we do have a Bill of Rights, and it has a very strong and pronounced guarantee of the environment. But then, of course, we have other rights as well. And I think one of the problems which is encountered is that in environmental cases, there are often other fundamental rights which pull in the opposite direction. So two examples come to mind. Every year or every couple of years, there are allocations of fishing rights. And the department that makes those decisions must balance, on the one hand, the desire to preserve fishing stocks and fishing resources, including for future generations, and on the other hand, the rights of coastal communities, sometimes poor ones, who are dependent on fishing for their livelihoods. The other example, I think it was from one of the earlier questioners on emissions, say, from factories and large industrial works. The right to clean air might require one to reduce those emissions, but if that threatens the continued viability of an industry that employs a lot of people in the area, that impacts on the right to a livelihood, which is also a guaranteed right. And I think in this country, although we've had our Bill of Rights for 30 years or so, we also encounter most environmental questions, I think, in the context of judicial review of administrative decisions, where the courts are being drawn into these political or polycentric executive issues, where it's not just a matter of saying the decision maker disregarded environmental considerations, but was the balance struck correctly? And I would be interested to know how, in the different jurisdictions, this question of competing interests is to be adjudicated. Does one say, well, the environment is for future generations, we hold it in trust, and that enjoys some sort of priority? Or does it just compete with other fundamental human rights? And sometimes the right to the environment will have to be sacrificed to the immediate interests of communities. And in Africa, including in my own country, that often includes the interests of indigent people, who are not always benefited by decisions which secure the environment. Sometimes they may be, but not always. Sometimes their interests are better served by relaxing a strict preservation of the environment approach.
Thank you very much.
Oui, notre Conseil constitutionnel a l'habitude de pratiquer un contrôle de proportionnalité. Nous avons des principes qui peuvent être contradictoires. Lorsqu'on parle droit de l'environnement, on se trouve souvent confronté à la question de la liberté d'entreprendre, au développement économique. Et le rôle de notre juridiction constitutionnelle, c'est d'apprécier et de réaliser un équilibre en tenant compte des garanties qui peuvent être apportées par le législateur pour préserver l'environnement. On ne peut pas faire obstacle à tout développement économique. Bien sûr qu'il faut encadrer, et nous sommes, nous, très attentifs aux garanties qui sont apportées par le législateur. Je l'ai dit tout à l'heure par rapport à l'enfouissement des déchets nucléaires. Nous avons tenu compte vraiment d'une quantité de garanties de la possibilité de reversibilité des opérations pour valider la disposition législative. Nous serons de plus en plus amenés à exercer ce contrôle de proportionnalité, et c'est pour cela tout à l'heure que je parlais d'équilibre et d'autorité bienveillante.
Yes, sir.
Thank you. My name is Jody Collopin. I'm from the Constitutional Court of South Africa as well. So in the context of this morning's discussion, it's clear that what has emerged from the speakers is that courts have a role to play, but politicians have a role to play as well, and perhaps even a bigger role, given the nature of climate change and how it manifests itself in its causes. Now, our Australian colleague has indicated that certainly from a common law perspective, their courts have interpreted there not to be a duty under those circumstances, but there may well be a duty located in statute. And other jurisdictions may come to a different conclusion on that question. And certainly in the context of South Africa, where the right to environment is constitutionally guaranteed, court may well come to a different conclusion that there is a constitutional duty in fact. And that leads to a consequence that our Indonesian colleague has spoken about, which is an unequal sharing of the burden. The result may well be that in some jurisdictions, some governments will carry a bigger responsibility simply because of their national frameworks. And therefore, the answer must lie somewhere beyond that. But if one looks at the world today, it's become much more inward-looking. Countries are focusing on their own self-interest, their national interest. And really my question is to our colleague from France, who has been involved in climate change negotiations. And I just want to get a sense from him whether, from his perspective, there is an appetite and a political will and a political commitment at the level where it must exist to address climate change, because if not, the burden will fall disproportionately on courts, and courts, with respect, may not have the capacity, nor the competence, nor the legal authority to address these issues. And then we find ourselves in limbo. So that's my concern and my question.
شكرا. السؤال موجه للسيد مازو، يقول بأن هل الإرادة السياسية يمكن أن تتغلب على قدرة القضاء على حل بعض المسائل، باعتباركم كنتم عضوا في النقاشات المتعلقة بقمة المناخ. سيد مازو، السؤال للسيد مازو. السؤال موجه لك.
مزاح.
سمعت سؤال.
C'est pour moi, for me.
Yes.
Yes. Oui, nous entrons un peu dans un délicat problème qui est la question de ce que l'on appelle le gouvernement des juges. Or, nous ne sommes là que pour appliquer ce que disent nos constitutions et le respect de la loi. De manière, peut-être avec un peu d'humour, je constate en France aujourd'hui que nombre de parlementaires contestent le rôle du Conseil constitutionnel en considérant que nous avons des décisions dans beaucoup de domaines qui censurent souvent les dispositions législatives, mais ce sont les mêmes qui nous saisissent régulièrement. C'est-à-dire qu'il y a là aussi un équilibre à trouver, mais le rôle de nos cours constitutionnelles, c'est de rester dans le cadre littéral de la Constitution. Et bien évidemment, il est important que ces dispositions constitutionnelles, et c'est le cas dans nombre de pays, vous l'avez rappelé, tiennent compte des évolutions de la société, des évolutions telles que celles de l'environnement. Il est bien évident qu'il y a 50 ans, on n'en parlait quasiment pas. Et beaucoup de pays ont déjà intégré, et depuis un certain nombre d'années, des dispositions constitutionnelles. Mais bien évidemment, parce que le sujet est tellement important, parce que nos concitoyens sont tellement préoccupés, et dans certains pays encore plus que d'autres, par ces questions climatiques, bien évidemment, les décisions de nos cours vont impacter le politique, même si nous ne faisons qu'appliquer ce que les parlements, ce que les citoyens ont voté.
Merci beaucoup. واضحة الإجابة? It's clear?
If I could make a contribution just on that. I think the last two questions and the observation of our colleague from Singapore as well are all disclosing that there are there are limits to the law. There are limits to what the law judges can legitimately do, and legislation, both national and international, cooperation is essential. Otherwise, there will be these challenges to judicial legitimacy about how is the judiciary, the right repository of power to determine the kind of balancing issues that our colleague from South Africa referred to. They're very difficult issues. They're the same issues in each country, which have been given a different resolution. I note that the ICJ advisory opinion, its conclusion was that the questions posed represent more than a legal problem. They concern an existential problem of planetary proportions. International law, and I would add in and national law, has an important but ultimately limited role in resolving the problem. So I think it's important to recognise that many of these issues are in the political realm, requiring that kind of action, as opposed to, as I say, the limits on what judges, particularly in a country like Australia with a strict separation of powers, where we do not trespass on the political sphere. I think they were important observations from all three observers.
Sir, you.
I was going to make an observation really along the same lines. To illustrate the point, in the UK, our institutional arrangements, our constitutional arrangements, give primacy in the constitution to our parliament, and we have a very effective democracy. Now, as a result of that, our government and our parliament have responded to public concern about climate change, concern particularly on the part, it has to be said, of the better educated people and younger people. It responded by enacting legislation which required the government to to achieve the objectives set in the Paris Agreement. It has to produce every 5 years details of how it is going to achieve those objectives as a rolling programme which is presented to Parliament and monitored by an independent expert body. And the court's role is essentially to ensure that the obligations created by the legislation are observed. Now, the advantages of that constitutional arrangement can be illustrated by this example. Our country is very rich in natural resources, in coal, oil, and gas. A decision has been taken not to exploit those resources, and instead to invest heavily in renewable energy, wind farms, tidal energy, and the like. Now, that has resulted in a very large increase in the cost of electricity in the UK. The consequence of that has been to make steel production uneconomic. And so steel foundries in the UK have closed, with the loss of thousands of jobs. Those jobs are in the poorest parts of the UK. And so one is getting, partly that is just one example, but examples like that show how the economic and social costs of responding to climate change in a developed economy like ours fall most heavily on the poorest members of our society. And there is a political reaction to that. It's one of the factors which is leading to greater support for what one might call populism in our political sphere. Now, when you have democratic authority through Parliament for the implementation of these changes, it has a legitimacy which it could not possibly have if it was the result of a judicial decision. The courts, as I explain, have an important role to play in ensuring the effective implementation of the legislation giving effect to the Paris Accord. But the difficult political decisions and political responsibility are borne by our political institutions rather than our judiciary. And I think that is, in our constitution, how it ought to be.
Thank you very much. You, sir?
Before I ask a question, I'd just like to say that for our colleague from Mozambique, a few years ago in Maputo, a number of us gathered for seminars on judicial education on environmental law. And sorry, I forgot to say, I'm Stephen Majid from the Constitutional Court here. And then from those fruitful discussions in Maputo, we established what is known as the African Judicial Education Network on Environmental Law. It's a mouthful, so we just called it AJNL. So there was a lot of cooperation and collaboration on judicial education on environmental law. Unfortunately, that's had some headwinds and it has stuttered and stopped. And I would like, just before I ask the question, ask those of our, let me just interrupt myself and say that the whole idea was to expand that collaboration beyond judicial education and to have collaboration within Africa on environmental law among judicial officers. I'd like to ask our colleagues who are here from Africa, and particularly also our colleagues from Mozambique, that we work on reviving AJNL and expand that to collaboration on judicial officers on environmental law. Now my question is this, the Inter-America's judgment and also the ICJ opinion, they are mere advisory opinions, but in some constitutions like ours, the constitution requires of us to have regard to international law, but also that international law has persuasive authority. I often hear from academics who teach environmental law and also from environmental activists that the courts are not doing enough. I'm speaking about South Africa, of course, that the courts are not doing enough in terms of environmental law. Some accuse the courts of being silent altogether. Others say the courts are not doing enough so that we see transformative environmental constitutionalism. Now, is it the opinion of the panelists, particularly our colleague from Australia who spoke about this landmark opinion, that this will change things because courts by their very nature are obviously reactive. We can only deal with matters that come before us. I hear people say the courts must be more active, but you can only be active in respect of what is before you. Is it your view that these two landmark opinions will make some sort of change? Because I think it's up to environmental activists and NGOs and citizens to bring these cases to us. Will there any changes as far as you see? And I'm speaking, of course, in common law systems, which ours is. Thank you.
Thank you.
Muito obrigada pela questão colocada. De facto, a questão da educação da lei, eu devo dizer que em Moçambique prossegue esta formação a nível interno e tem sido levada não apenas para os tribunais, mas, por exemplo, para o Ministério Público, para a Administração Nacional das Áreas de Conservação e também para o Serviço Nacional de Investigação Criminal. E outra nota que também posso deixar é que recentemente várias faculdades também adotaram a cadeira do direito do ambiente, que era uma cadeira que existia apenas na Universidade Eduardo Mondlane. Isto já espelha a preocupação da educação das leis ambientais, para além também de outros, de alguns seminários públicos que têm sido levados a cabo e algumas publicações feitas pelos docentes desta cadeira do direito do ambiente. Quanto à questão desta lei, que seria uma lei africana do direito do ambiente, devo dizer que, bom, não está a conhecer a evolução que se pretendia, e penso que aqui também o poder político tem uma cota de responsabilidade, se bem que também entendo que os tribunais, a sociedade civil devem ter o seu papel fundamental persuadindo para que de facto seja levada avante esta legislação, que afinal é de interesse e de benefício da África. Obrigado.
Madame Jago, you can add something? You have a question? Yes.
I think in at least the Australian system, the international decisions, I mean, there are all sorts of channels of thought and osmotic processes that go on, and I can see that those kinds of decisions, although they're not directly applicable in Australian law at all, but they will undoubtedly in some ways contribute to political and social thought in the country, and so they're important in that sense. Our system is a direct inheritance from the English system of parliamentary supremacy, and so this is why I see the role, I guess, of the judiciary is, at least in our system, limited to applying the law as it is, and based on the current state of the law, legislation will be of imperative importance, and they are political decisions for which the political parties answer in effect at the ballot box, and that is how our system operates.
شكرا. فقط سيد نجيب ممكن أن أضيف حول سؤالكم عن الآثار التي قد تترتب على الرأي الاستشاري لمحكمة العدل الدولية. معروف أنه رأي استشاري غير ملزم، ولكن من حيث المضمون أنه يشير إلى أن هذه الالتزامات القانونية للدول تجاه تغير المناخ هي ناجمة من قانون تعاقدي أو من اتفاقية دولية ومن القانون العرفي الدولي، وكذلك من حقوق الإنسان، القانون الدولي لحقوق الإنسان، لأن تغير المناخ يمس بالتزامات الدول بضرورة احترام حقوق الإنسان، خاصة ما تعلق بالحق في بيئة سليمة، الحق في مناخ نقي، والحق في الحياة، وخاصة حماية حقوق الأجيال القادمة. ولعل الاحتفاء والإجماع على أهمية هذا القرار والتصويت عليه بالإجماع لخامس مرة منذ إنشاء محكمة العدل الدولية ربما سيكون له دافع كبير حتى تلتزم جميع المحاكم بهذا الرأي رغم أنه استشاري. شكرا. إذن أطلنا كثيرا في الأسئلة، شكرا على تفاعلكم، ولكن في الأخير يمكن أن أقول بعض الكلمات. أقول أن رغم أن العدالة المناخية تحاول أن تميز بين طرفين، بين طرف ملوث ويستفيد من هذا التلوث وطرف متأثر بالتلوث وهو الدول النامية وهي المتأثرة كثيرا بآثار تغير المناخ، ولكن في الأخير أعتقد أن البشرية كلها مهددة بتغير المناخ. الأجيال القادمة هي المتأثرة بتغير المناخ. دليل على ذلك أن أغلب القضايا البيئية الشهيرة قد رفعت من طرف الشباب، وحتى رأي محكمة العدل الدولية الاستشاري بدايته كانت من طرف مجموعة من الشباب، ولعل تصريح الأمين العام للأمم المتحدة بقوله أن الشباب قد انتصر دليل على أن الأجيال القادمة هي المعنية بتغير المناخ، وبالتالي هناك وعي كبير وعميق بأن هذه الأجيال هي التي تدافع عن حقوقها في المستقبل، وإلا ربما في المستقبل سنفقد جيلين أو أكثر بسبب تغير المناخ. يمكن أن أجمع ما ورد في هذه المداخلات في بعض النقاط، وأتمنى أن يوافقني المتدخلون. ومن خلال المداخلات الأربع يلاحظ أن هناك اتفاق حول مجموعة من النقاط، حول العديد من النقاط القانونية والقضائية. من أهمها عالمية ظاهرة تغير المناخ، ومن ثم يتعين أن تكون المواجهة عالمية من خلال آلية التعاون القضائي البيئي. النقطة الثانية هي أنه من خلال التجارب الأربع التي عرضت على المنصة، التجربة الأندونيسية والفرنسية والأسترالية والموزمبيقية، هناك إدراك لخطورة تغير المناخ على حقوق الإنسان، وخاصة على حقوق الأجيال الحاضرة والمقبلة على الخصوص. هناك اتفاق على أهمية التعاون القضائي من خلال تقرير مسؤولية الدولة عن حقوق الأجيال القادمة تحت عدة تأسيسات دستورية وقانونية، لا سيما الحق في التنمية المستدامة والحق في البيئة. كذلك من المهم التأكيد على أن من أهم الآثار والمخاطر هو اللجوء المناخي، وهذه ربما لم تنل حديثا كثيرا في القاعة، ولكن يبدو أن اللجوء القسري موجود بسبب تغير المناخ، بل أن هناك إحصائيات تقول أن عدد النازحين بسبب تغير المناخ هو أكثر من النازحين بسبب الحروب وعدم الاستقرار السياسي. هذا النزوح المناخي الذي أصبح يهدد حق الإنسان في الحياة وبشكل متنافي، ويجب التصدي له من خلال المسؤولية القضائية. كذلك من بين النقاط المتفق عليها يمكن من خلال المداخلات الأربع الخروج بتوصية عامة مفادها أنه لا بد من توجه المجتمع الدولي إلى وضع اتفاقية دولية للعدالة المناخية لتطبيق مبدأ التوزيع العادل بين المخاطر والفوائد، وهذا هو مدلول العدالة المناخية بين الدول الصناعية والدول النامية. اتفاقية تعزز مبدأ العدالة بين الأجيال وبين الدول وبين الطبقات داخل المجتمع، ومبدأ المسؤولية المشتركة ومبدأ المسؤولية المشتركة. إذن هذه أهم النقاط التي رأينا بأنها تجمع كل هذه المداخلات. إذا وفقنا فنحن محظوظين، وإذا جانبنا الصواب فنطلب العذر. شكرا لكم على حسن الانتباه والمتابعة، والسلام عليكم. إذن نترك المجال للمنظمين لمواصلة البرنامج. لتفضلوا مشكور.
Yeah.
Sorry.
Colleagues, our efficient steward
Okay? Thank you. Good. But I will translate in Korean because I practice only this. Sorry. So, those who need to use translation devices, please put them on. Thank you very much. 네, 안녕하십니까. 저는 한국에서 온 한국 대법관 노경필입니다. 먼저 이 자리를 마련해 주신 미아 헌법재판소 소장님과 남아공 관계자분들께 진심으로 깊은 감사의 말씀을 드립니다. 존경하는 저스티스 여러분들을 모시고 이번 세션을 진행하게 된 것을 무척 영광스럽게 생각합니다. 저는 한국에서 약 30년 동안 법관 생활을 하였고 1년 전에 대법관으로 임명되었습니다. 저에게 약 5분의 시간이 주어져 있어서 먼저 한국의 사법제도에 대해 간략히 말씀드리고자 합니다. 한국의 대법원은 대법원장을 포함해서 14명의 대법관으로 구성되어 있습니다. 한국의 대법원은 한국 사법부의 최고의 법원으로서 모든 법률 쟁송에 대해서 최종심으로 심판하고 있습니다. 남아공과 마찬가지로 한국에도 헌법재판소가 설치되어 있기는 하지만 한국의 헌법재판소는 헌법이 정한 몇몇의 특별한 재판만을 담당하고 있습니다. 위헌법률 심판이나 탄핵 심판, 정당해산 심판 등이 그것입니다. 한국의 헌법재판소는 일반적인 법률 분쟁에 대해서는 심판하지 않습니다. 따라서 법원의 재판에 대해서도 심판할 수 없고 관여할 수도 없습니다. 이것이 남아공 등 헌법재판소가 설치된 다른 나라들과 다른 한국 사법제도의 가장 큰 특징 중에 하나입니다. 그러면 이제 본 주제로 돌아와서 이번 세션을 진행하도록 하겠습니다. 이 세션의 주제는 모두가 아시다시피 사이버 범죄 퇴치, 국경을 넘는 사법협력 강화입니다. 이번 세션의 목적은 사이버 범죄 퇴치를 위한 국제사법협력과 관련하여 초국가적 문제와 사법협력 강화 요구에 대해 살펴보고 이러한 문제들이 사법부에 미치는 영향과 이를 해결하는 데 사법부가 수행할 수 있는 역할들을 논의하는 것입니다. 또한 변화하는 환경 속에서 G20 국가의 최고법원과 헌법재판소가 직면한 도전을 공유하며 각국이 사이버 법적 대응과 글로벌 현안 해결을 위해 어떻게 전략적으로 협력할 수 있을지 모색하는 것입니다. 이번 세션을 통해 초국가적 문제 해결을 위한 모범 사례, 경험, 법적 혁신 및 해결책을 공유함으로써 각국 사법부가 신흥 위협으로 보상한 사이버 범죄에 대해 어떻게 대응해 왔는지에 대한 통찰력을 얻을 수 있기 바랍니다. 그럼 지금부터 4세션의 발표를 시작하겠습니다. 발표자들께서는 원칙적으로 20분 발표를 해주시고 그 뒤에 25분 동안 패널 토론 및 질의응답 시간이 있을 예정입니다. 이번 세션을 통해서 생생한 경험과 비전을 함께 나누는 유익한 시간이 되기를 바랍니다. 자, 첫 번째 순서로 러시아 헌법재판소의 재판관이신 저스티스 코노발로프 씨입니다. 이분은 2008년 5월부터 2020년 1월까지 법무부 장관을 역임하셨고 2025년부터 러시아 헌법재판소 재판관으로 활동하고 계십니다. 경험과 통찰에 담은 훌륭한 발표를 해주시라고 믿습니다. 여러분 큰 박수로 모시기 바랍니다. Sorry.
Honourable Member, Madam Chief Justice of South Africa, Mandisa Maya, Honourable Presidents and Justices of Highest Courts, dear colleagues, it would be difficult for the organisers of this forum to find somebody less skilled in IT technologies and less prepared to speak on cyber crimes as an IT expert. Even this iPad that I use now belongs to my younger son. I do not possess any. Still, I will try to share with you some thoughts of myself and some ideas as a lawyer, of course not as an IT expert, as we all do believe that the lawyers should have some opinion anytime, and they even say that when there are two lawyers, there are at least three opinions. Not kidding anymore, because the topic of the last panel is quite serious. But let me start with expressing gratitude to the possibility to speak before this high-level forum. I'm also glad to wish you all the best on behalf of the Chairman of Constitutional Court of Russian Federation, Dr. Valery Zorkin. I also would like to thank Her Excellency Mandisa Maya for organizing of this event and to congratulate her with the very good discussions that had happened already. The topic of cybercrime, just as other topics discussed at this summit, is undoubtedly relevant. All the issues discussed are affecting every state to a certain extent, and they are generally cross-border, thus calling for cooperation between different countries, including judicial cooperation. It is all the more valuable that today we are engaged in these professional discussions. In 2024, the damage from cybercrime in Russia has amounted to some $2.5 billion of American dollars. More than 370,000 IT crimes were registered. The great majority of these crimes are theft and fraud. Less than 10% of all crimes registered are the computer crimes themselves, such like creation of harmful computer programs. Thus, most crimes in the IT sector are old crimes in the new digital reality. And yet, this new reality creates a whole range of practical difficulties for the fight against these crimes in their detection, qualification, proving criminals' guilt, bringing them to the court, and resorting the rights of the victims of these crimes. Probably the most significant difficulties presented by the new cyber reality to crime fighting are the widest spread of criminal activity locations around the world, the differences of places where crimes are committed, interim transactions are performed, harmful results are affected, criminals, witnesses and victims are located, and the many sophisticated and ever-changing facilities to cover crimes and true identities of criminals. Crime readily and actively seizes the lack of any authorities' control over a major sector of global internet network, as well as differences in approaches of various jurisdictions to regulating the digital sphere, and lack of coordination of the law enforcement authorities placed on different sides of the state borders. One of the aspects of this new reality is the existence of practically autonomous so-called darknet markets with their own rules and principles, good shape of which break or simply ignore the official jurisdictions. The legal order definitely faces some technical difficulties because of this. The swift technical progress creates obstacles for timely passing of laws. The possibilities of judicial interpretation for expanding existing normative framework are often limited and not always can be effective. Therefore, the fight against the newest manifestations of cybercrime may sometimes appear fragmented. Update of international regulation is slow, and the authorities' reactions can be delayed and insufficient. Certain problems may be viewed out of context and cause imbalance in legal regulation. Therefore, it seems that we should start with ensuring full, comprehensive, and relevant monitoring and analysis of the modern cybercrime, and with form on this basis a systematic approach to crime detection, destruction and prevention in all the necessary and required aspects of this work, combining all the types of juridical instruments, economic and humanitarian impact factors. Combating cybercrime requires a broad approach, from educating citizens in basic cyber security to modernizations of specialized training of law enforcement bodies, introducing additional requirements to banks, training higher-level IT experts and specialized judicial panels. Each component of this work has its final goal as ensuring protection of rights of citizens and society from the threats of abuse of new technologies. The tried and tested, most traditional and possibly still the most effective way of combating dangerous, harmful activities is criminal prevention. Some provisions of criminal law can be explained by the Supremes and constitutional courts. The court practice and legislation are called to respond as timely as possible to new forms of cybercrime and new elements of criminal schemes. As noted before, the wide opportunities to anonymizing criminals create serious obstacles for criminal prosecution. Just a short example. Some time ago, the phenomenon of dropping has spread in Russia. The criminals use bank cards of third persons to receive money they have stolen or to create several stages of its transfer. Often the droppers are the teenagers who act for insignificant reward, a share of stolen money. The organizers of fraud themselves might remain outside national jurisdiction. In this connection, the legislator has introduced particular criminal liability for acquiring an electronic payment device for a third person and conducting illegal operations with the use of the payment device. The new norms have entered into force on 5th of July 2025. In those legal systems where, apart from criminal prevention, there is so-called administrative prevention, including Russia, the latter is also, as we believe, capable of punishing and preventing illegal activities in digital sphere. Administrative norms may be more flexible and more casuistic than criminal ones, enabling the authorities to react less strictly to less dangerous offenses and stopping illegal and socially dangerous activities early, thus allowing the offenders to make up their minds and stop prohibited activity. Also in Russia, where only natural persons are criminally liable, the administrative jurisdiction provides prosecuting of the legal persons and punishing them with the large fines, disqualifications and prohibition of certain activities. As it was already said, the special feature of cybercrime is its most wide geographical spread and opportunities to make use of any differences between approaches of national jurisdictions. This demands consideration of the issue of a more serious and effective international cooperation than the one deployed against general crime. Here, there is no place for outdated approaches, bureaucratic delays, and incorrectly understood political interests. As the well-known concept puts it, crime has no nationality. And given the new capabilities that criminals have gained with their access to borderless world and the new technologies, it is our common interest to counteract in a coordinated and effective manner. On our planet, there may be no quiet harbors or grey zones for criminals where they could easily hide, blend in, legalize and use their criminal gains. Actually, they must have the earth burning under their feet. They must feel constant threat of prosecution and imminent perspective of being captured by justice and put before court, and the illegal actives transfer to other jurisdictions must become pointless because of synchronized state approach to countering their deployment and legalization. Increased level of cooperation between financial and banking systems is relevant to prevent criminal withdrawal of money, between police and special services to disclose, expose and destroy criminal schemes and criminal groups, among courts to ensure extradition, effective criminal prosecution and return of stolen assets. At the same time, we must not become similar to criminals in their methods of our fight. However important are the goals and aims of criminal prosecution or a recovery of illegally gained assets, the national jurisdictions must not resort to kidnappings, fabrication and falsification of evidences, torture or psychological pressure in order to obtain confession of guilt or plea bargain, or to apply one's legislation outside its jurisdiction. Generally, the problem of the proper balance of public interests and private rights is important, especially while investigating and prosecuting the really dangerous and sophisticated criminal activities, where the authorities should be determined and efficient. More than that, the old crime, using the new opportunities, is dangerous, but apart from trivial types of criminal activity, in new forms and with new capabilities offered by digital technologies, there is also an especially dangerous part of cybercrime that must draw most serious concerns and most active counteraction on the part of the authorities. It involves truly professional IT specialists and significant financing, and its final beneficiaries are most likely the serious influence groups. Mass DOS attacks and collapse of websites of state authorities, large monopolies, transport and energy companies aim to disrupting critically important processes and even to block vital service systems, to pose obstacle for normal functioning of whole societies, creation of terrorist and extremist networks, systems of recruitment of terrorists and organization of terrorist attacks, provocation of mass disorders and attempts of state revolts, terrorist attacks and attacks on infrastructure objects. All this today is done with active involvement of digital technologies. Producing the fake news and fake court evidences using the AI and IT technologies has also become a particular kind of the dangerous activity. As in the case with general criminality, countering evil in this segment calls for systematic analysis, which must be full and verified without any political engagement and concern the understanding of present and prospective threats, the aims, possibilities and motives of criminals, the available resources to counter the schemes and the most effective ways of their deployment. Most importantly, we must have a common culture and common understanding that this segment of illegal activities, such ways of achieving of somebody's selfish goals, go hand in hand with the most serious risks of normal existence for life and health of millions of innocent people. Those who can sacrifice others' interests and even lives are actively using new technologies, join their forces and have no burdens in the form of moral or ethical principles. Unlike them, we have law and rule of law on the heart of all our actions, but we must not lose in terms of efficiency. However strong, united, armed and dangerous may be the international criminal networks, the states with their powerful enforcement mechanisms, and what is more important, with their humanistic goals, will be stronger by definition. This is why it is so important to take a sober, balanced, strict and consistent approach with regard to joining forces in fighting cybercrime and to take specific steps to this end. We talked about the rule of law yesterday. There is no doubt that the law should be the main measure of all behavior, primarily the behavior of any barrier of the public authorities. But at the same time, experience has shown that the attempts to understand the rule of law as a pattern, as a unified standard model, are counterproductive. The phenomenon of law retains internal relationship with the value system of national jurisdiction, in one way or another reflected in the constitutional text, and in its essence is related to the concept of the constitutional identity. So we should build up not a pattern, but a common culture of understanding both of our differences and our common priorities. Such priorities can be really new. Traditional law, in our usual understanding, is increasingly losing its mandatory element, that which the theorists of legal positivism may have always believed is the provision of sanctions. Freedom of movement and residence, permissible anonymity of many types of behavior, lack of control by the states of both digital environment and increasing segment of social processes actually deprive the law and judiciary of their traditional sanctioning force. The so-called soft law and the horizontal structures of society being used solely and non-alternatively could be probably not sufficient, or at least need some measures to be realized, to be integrated in the modern legal world. So the issue of either radical update of the system of execution of the court decisions, including outside the jurisdiction, or development of new approaches to understanding law, or both, seem to be on the agenda. Of course, the cybercrime prosecution has some certain specific needs, more quick, sometimes immediate and intensive reactions, information exchange, more mutual trust. But there is still nothing in this sphere in terms of international cooperation that cannot be provided by both the police and special services and by the national judiciary. If the governments could create this mutual trust and common culture and make some certain common decisions, the common practical steps promoting them could be provided for sure. What else could be done by the judiciaries to make these decisions and this mutual trust more close? I do believe the answer is in the very competency of the high and constitutional courts as it is. One way or another, in common law system, this function of the courts is more articulated, but it is typical for the civil law system as well. These courts are working out the general principles and the best practices of lawmaking and law enforcement. Despite some differences in the doctrinal and practical aspects of our national legal systems, we all belong to, quoting Chairman Zorkin, to the civilization of law, and will definitely become closer to each other when we base our national models of legal practices on the well-known and shared constitutional principles, when we discuss our attitudes and opinions and share them too, making these practices more close to each other as well. I'd like to recall that the UN Convention Against Cybercrime has been adopted by the UN General Assembly on 24 December 2024 after 5 years of preparation. The Russian Federation was among the initiators of the UN General Assembly resolution to develop this convention and has prepared and submitted its draft. It is our belief that the convention creates a strong foundation for balanced and effective cooperation of law enforcement authorities in the sphere of fighting cybercrime and will become an adequate answer to this modern threat to the benefit of security of states and citizens' rights. Honorable colleagues, just 30 years ago, many things that we presently consider everyday reality would seem outright fantastic. The world surrounding us is full of new technologies, simplifying our actions, communications, and decision-making. Digital environment itself become independent reality, and the online and offline world has become practically equal. Digital technologies and practices are following legal contracts and transactions, and completely new approaches and instruments have entered legal reality. Sometimes this new reality seems to be truly frightening. There can be a feeling that traditional law that we became used to, seeing it and trusting it, is incapable and has no chance of catching up with this new reality and to deal with the massive avalanche of problems. I think that despite some objective complexity of the situation, we must not fall in panic and pessimism. As said before, new technologies are only serving and facilitating motives and interests that are well known since ancient times. However, the contract is concluded, be it through the ancient Roman mancipatio procedure or blockchain and cloud technologies, the idea is still the same: to sell or buy property. Behind all the unique and perfect technologies, there are things well known to us, such as pursuit for happiness and avoiding suffering, charity and selfishness, goodwill and badwill, truth and lie. However difficult and diverse, even frighteningly diverse, is the world, we still have at our disposal the truths and principles tested by centuries of human civilization, which are fulfilled in our constitutions and basic laws, in the systems of our life values. These principles are greatly corresponding to everlasting features of human nature and rules of social relations, and ensure our universal goals and our best future. Our courts, implementing them, are the guardians of the higher legal truths, the perfect standards of legal practices. If our legal systems in cooperation remain loyal to these principles, I am sure that they will overcome all challenges and all threats. Thank you very much for your attention.
수고 많으셨습니다. 아주 경험과 통찰이 담은 좋은 발표였던 것 같습니다. 다시 한번 깊은 감사의 말씀을 드립니다. Justice Konovalov, thank you. 다음 발표는 아일랜드 저스티스 머레이 씨입니다. 머레이 대법관님께서는 아일랜드 대법원에서 근무하고 계시고 국제관계 수석 대법관으로 활동하고 계십니다. 그는 2022년에 대법관으로 임명되었으며 그전에는 항소법원의 판사로 근무하셨습니다. 현재는 트리니티 로스쿨에서 강의도 하고 계십니다. 네. 훌륭한 발표를 해주시리라고 믿습니다. 박수로 환영해 주시기 바랍니다. 감사합니다.
Chief Justice Maya, judicial colleagues, judicial friends, ladies and gentlemen, I am extremely grateful to Chief Justice Maya for her invitation to attend and observe these proceedings on behalf of the courts of Ireland. Ireland is not a member, of course, of the G20, but I know that our government was honoured when requested by South Africa to participate in G20 as a guest country during South Africa's presidency. The invitation reflected the strong and deep bonds between our two countries. The Irish judiciary is similarly honoured to be asked to take part in this groundbreaking event and hopes this experience will further cement our relationship with our colleagues here. In fact, as I was in the latter stages of preparing my paper, it occurred to me how frequently and strangely things can come back around. I'm here today before you in South Africa as a judge of the Supreme Court of Ireland. I will be talking somewhat in the course of my paper about the role of judges in the international protection of human rights, as indeed many of the other speakers have done. Yet my introduction to international human rights law came at the law school in Trinity College, Dublin, in the early 1980s, through the tuition of Kader Asmal, the inspirational South African barrister, academic lawyer, human rights and anti-apartheid campaigner, and later minister in President Mandela's 1994 government. A lot of our folklore is more the product of fond and vivid imagination than of fact, but our folklore has it that the earliest iterations of the South African Bill of Rights were prepared by Kader and the redoubtable Albie Sachs on the kitchen table in Kader's Dublin home. I cannot personally attest as to whether this is true, but I can personally attest that if it is true, it was a process of drafting that was lubricated by copious quantities of Irish whiskey, served hot in Cadder's favoured style. And I was tickled when I saw at the Chief Justice's generous reception on Tuesday evening that that same libation was being liberally distributed. Things have a way of coming back around. It is hard not to be impressed by the precision with which the topics chosen for these discussions have captured some of the most important questions facing judiciaries today. Judicial conferences of this kind are, of course, critical to the process of enhancing the quality of justice administered in all of our courts. They afford an opportunity for judges from diverse backgrounds to both identify and in their own work to build upon commonalities of experience and outlook, while at the same time learning from differences in our legal systems. All of that is key to developing workable models of judicial cooperation into the future. And there are few areas in which such cooperation is more practically important in the borderless world to which reference has been made throughout these sessions than in the area of cyber crime. The reasons that cooperation in that field is so important are obvious. Cybercrime is ubiquitous, dangerous, disruptive, and costly. Criminals are not inhibited by national boundaries, and responses to their crimes must be similarly unconstrained, or at least as unconstrained as the due administration of justice and protection of human rights will permit. As the European Commission put it in one of its many working documents on this issue, the internet is borderless for everyone except authorities pursuing criminal investigations. It is worth taking a moment to reflect on what we're dealing with. As with all legal issues, there are questions of definition. Cybercrime may be described broadly as computer-related crime, any illegal behaviour committed by means of or in relation to computer system or network. On that basis, today, cybercrime covers a vast swathe of criminal behaviour. It captures not only most financial crimes, but exploitative offences such as child pornography or grooming and sometimes trafficking of vulnerable persons. In fact, outside even that parameter, even where digital technology is not a direct or indirect instrumentality of criminal behaviour, digitally stored data often provides strong evidence of crime. It does this because most communications are now reduced to that form, and thus relevance to guilt or to innocence can often only be secured through the interrogation of digital devices. An example from a recent case before our court shows this. We were told in the course of our hearings that it's very common for inexperienced first-time criminals who engage in serious wrongdoing to resort to Google to inquire about the consequences of what they had just done and how they can avoid detection. They thereby create a permanent record of their own guilt. That is the price of inexperience. We were concerned in our case with the legal question of what judicial authorization was required to access a computer seized in the course of a very standard search of a dwelling. It was a murder case tried in the lower courts on circumstantial evidence. The body had been concealed on a farm after the alleged killing. The evidence included the fact that the accused had, very shortly after the estimated time of death, entered in Google 4 words: human body decomposition timeline. The point is that evidence derived from electronic devices is everywhere. How the prosecution gets that evidence is key, and so, therefore, is the question of where exactly it is located and how precisely it is to be obtained if outside the jurisdiction. More focused definitions relate cybercrime to illegal behaviour directed by means of electronic operations that target the security of computer systems and the data processed by them. Even within that narrow frame, the consequences of such wrongdoing for economies, for public and private institutions, and for state infrastructure are potentially horrendous. A study last year concluded that if global cybercrime were treated as a single economy, it would be the third largest in the world, at $10 trillion, coming after only the economies of the United States and China. Research also suggests that much of this is not being prosecuted. And one of the reasons it is not being prosecuted is because of the difficulties encountered by investigators in accessing information necessary for that purpose. This presents the prospect that cybercrime creates the irresistible combination of high yield and low risk. Some of the technical problems are fairly obvious. Evidence may be on devices. It may be in the cloud, but accessible by investigators only through the agency of the service provider. It may be in data centres. It may have been in a data centre in one jurisdiction, only to have been moved to another. By the time investigators come to look for information, it may have been destroyed, or it may appear to have been destroyed, but be capable of reconstruction. The European Commission, in its working papers, gives many examples from its practice and from evidence given to it. I'll take just two of them, which I think demonstrate the breadth of the problem and its significance. After a terrorist attack in Germany, they said, the German police find connections of the suspect terrorist to a cell that's been involved in other terrorist attacks in France, Belgium, and Spain. The suspect has been in Syria, Turkey, and Morocco. The German police have indications that the terrorists communicated through email drafts. One terrorist drafted an email and instead of sending it, saved it to the draft folder, accessible online from anywhere in the world. The other terrorist opened the same account and read the message. Because the email was never sent, it was not possible to track. How does the prosecutor locate and obtain that evidence? The answer in that case was by, in fact, coming to Ireland, because the Microsoft server hosting the account happened to be there, and procedures were invoked under legislation in our jurisdiction to enable its release. Child sexual abuse, another example. After having infiltrated a website for exchanging child sexual abuse material in the darknet for more than a year, the Australian police gathered information on more than 1 million users globally, which they've started to distribute to law enforcement around the world. Some of the child victims appear to be in Germany. The investigation has revealed the offender's Facebook profile. The prosecutor obtains crucial information by invoking mutual request procedures with Facebook in the United States to gather more information about the possible offender's exact location. And there are many more examples that could be multiplied. All of this, of course, is grist to the mill of lawyers who will argue issues of jurisdiction not merely over crimes, but even over the ability of courts to facilitate disclosure. In particular, nice legal questions arise as to whether individual states have power under their own laws to require companies based in their jurisdictions to disclose information housed in data centres outside those jurisdictions. Similar questions arise around where data in the cloud legally exists and what jurisdictions have the power to direct its release. So, evidence of a single crime of this kind may be located at the same time in several jurisdictions. It may, at the same time, be located in no jurisdiction. Offences may be both contemporaneously committed in many places, yet very difficult to connect to any one state. Even if it has no physical manifestation, accessing various different strands of an investigation or prosecution will require cooperation between states. The crucial role for mutual assistance between courts is thus self-evident. Cybercrime is an international problem, and the solutions to the unique challenges it presents are inevitably products of diplomacy, of politics, of agreements between states, and of legislation. These are necessarily conditioned by sometimes differing perceptions of the scope and limits of national sovereignty. To work effectively, that requires structured and considered multilateral treaties. For almost 25 years, there have been various conventions seeking to regulate mutual judicial assistance in this field, starting with the Budapest Convention in 2001, concluding most recently with the United Nations Cybercrime Convention, referred to by my friend and agreed on Christmas Eve last year. There have also been regional agreements, including those of the League of Arab States in 2010 and African Union in 2014. All of these attempts to provide frameworks for judicial cooperation have to address difficulties and complexities inherent in the subject matter. There are altogether 6 aspects of this I want to specifically mention. First, some of these conventions were drawn for a different time. The Budapest Convention, which was the first, most influential, and to date most widely ratified, predated the explosion of the internet, the emergence of the Internet of Things, cloud computing, and the transformation of almost all forms of communication to digital format. While it has been the subject of 2 protocols, questions remain as to its fitness today. Second, certain requests for assistance can be addressed under police-to-police cooperation, or in at least some jurisdictions, by direct dealings between requesting states and service providers holding information in another jurisdiction. That is relevant to the collation of voluntary statements and the provision of witnesses who are prepared to present in another jurisdiction. And in many systems, it is possible for non-content data, such as subscriber details, to be exchanged in this way. In that situation, the intervention of the courts is not required. Third, however, in many jurisdictions, service providers will not cooperate in the compulsory disclosure of data, and in particular of content data, unless compelled by legal authority to do so. Certainly in the EU jurisdictions, the combined effect of the data privacy rights provided for in the EU Charter of Rights and Freedoms and certain EU directives is to require an assessment by a court or independent court-like body prior to the making of such disclosure in many cases. That will require that those whose data is thus to be disclosed be enabled to make representations as to why this should not occur, and it is thus at that interface that judicial cooperation comes into its most critical focus. As we all know, when matters move into the judicial domain, pressures on resources, the need to ensure due process, the complexity of legal argument, and the availability of appeals can slow down any procedure dependent on judicial resolution. Yet, and fourth, speed in accessing data may be absolutely key to some of these investigations. Digital evidence is volatile. It can be manipulated. It can be moved from one jurisdiction to another, and indeed it can be erased or seemingly erased. That problem is exacerbated by the fact that some constitutional courts have set their face against mandatory data retention rules and the consideration that data minimization requirements imposed by some laws or courts force service providers to delete data quickly. Fifth, the most intrusive form of mutual assistance, the extradition of those accused of offences to another jurisdiction, is complicated by the fact that many states require correspondence of offences before they will render, particularly their own citizens, to another jurisdiction. In the case of new and involved offences falling within the description of cybercrime, this is not always easy to establish. Sixth, and finally, while the transmission of evidence to enable courts in other jurisdictions to proceed with their investigations and prosecutions is important, it cannot be enabled without regard to data privacy rights that may be engaged by compulsory disclosure of private information to foreign state authorities. In many cases, these can be protected by a proportionality analysis weighing the interest in disclosure against the nature of the impairment, and while that can be time-consuming, this is the least of the problems. Judiciaries must also consider what constraints will be placed on the use or onward disclosure of seized information, and whether those restrictions, together with rules on retention, provide adequate protection for data privacy rights, having regard to the requirements imposed by the law of the requested state. They must consider whether any restrictions on onward transmission or derivative use will be observed. State governments must consider even broader issues, many of which have troubled the Court of Justice of the European Union over the past decade. Aside entirely for targeted requests for access to data for specific purposes of particular investigations, what personal data of their citizens is generally being taken from their jurisdictions to other jurisdictions, and what constraints on such transfers should the law impose. Our overall objective as judges when negotiating this maelstrom is as easy to express as it is hard to implement. The commitment of judges to the due administration of justice within our respective jurisdictions demands that such legal powers as are available to us are deployed in the protection and vindication of victims of such crimes, and the deterrence of unlawful interferences with the integrity of our society's economies, infrastructures, and institutions. We must at the same time balance these considerations against our commitment to the safeguarding of the human rights of our citizens. This demands that powers of this kind be exercised so that entitlements to informational privacy are not impaired any more than is necessary to achieve those objectives. We must also endeavour to ensure that the private data of our citizens is not removed from jurisdictions in which those privacy rights are protected to those in which data may be abused by state or non-state actors. And that is where judicial cooperation has such a crucial role to play in the process. As I said earlier, much of this falls to be resolved through non-judicial channels, diplomacy, politics, agreements between states and legislation. But the one certainty is that our judicial systems will have to negotiate more and more of these issues, and our ability to do so can be significantly enhanced by well-considered methods of cooperation. We can perhaps discuss these further in the course of our conversations later in the session. But judges, through cooperation with each other at international levels, can reduce delays by standardising and understanding from each other the requirements imposed by each other and by respective jurisdictions for those seeking requests of this kind in terms of information to be provided and substantiated. There are strong arguments for enhancing liaison between and common education of judges in states that have executed bilateral or multilateral treaties, not only as to the law governing these requests and the way in which colleagues in other jurisdictions have navigated the balance between the public interest in the investigation and prosecution of crime and private interests in data, but also education as to the constantly developing technologies, understanding of which is often key to the exercise by judges of functions within this framework. We must acknowledge also the legal imperative that there must be judicial supervision of access to data in some situations for the purposes of cross-border investigations, and the factual reality that that supervision comes at the cost of delay. We need to devise mechanisms that mitigate the effects of this. For example, the Court of Justice has suggested freezing orders which prevent the deletion of data for cause, allowing time for the entitlements of those seeking access to the data to be properly and reasonably adjudicated upon. And finally, within our own systems, we perhaps need to consider, in conjunction with our colleagues in other jurisdictions, how our own domestic law inhibits the fast and effective provision of assistance of this kind. The reality is that as the effects of cybercrime becomes more and more evident, and as technology increasingly enables the concealment of wrongdoing, we need to constantly review, with the benefit of ongoing experience, where and how the balance between informational privacy and the public interest in the detection and prosecution of crime is properly drawn. That experience can be meaningfully enhanced by our understanding of how our colleagues in other jurisdictions have navigated the law. Thank you.
네, 수고 많으셨습니다. Justice Murray. 사이버 범죄의 퇴치와 인권 보장 사이의 그 긴장과 조화에 대한 아주 많은 고민을 하게 하는 아주 훌륭한 발표였던 것 같습니다. 다시 한번 감사드립니다. Thank you. 마지막 발표입니다. 마지막 순서는 아프리카 인권법원의 그 저스티스신 은채배차님이십니다. 예. 이분은 2021년에 아프리카 인권법원의 저스티스로 임명되셨으고 남아공의 시민이십니다. 네, 박수로 맞이해 주시면 감사하겠습니다.
Good afternoon. Yeah, I thought there were people in here. Good afternoon. At least that's better. Yeah. Let me cut to the chase. Honorable Director, Program Director, distinguished guests, and by that I mean various Chief Justices, heads of appeal court, judges, esteemed colleagues, ladies and gentlemen, comrades and friends, all protocols observed. Good afternoon to you all, and welcome to Johannesburg. It is indeed an honor and privilege to join this distinguished gathering. On behalf of the African Court on Human and People's Rights, I bring you warm greetings from Arusha, the seat of our court, where we are presently convened for our 78th ordinary session. The topic, the theme of combating cybercrime, strengthening cross-border judicial cooperation, could not be more apt. We are living in a fast evolving digital era, where the world is increasingly reliant on technology, as we heard in the previous discussions, even from yesterday. Very frightening, especially earlier on. We rely on technology, and technology has undoubtedly unlocked vast opportunities, but it has also exposed us to unprecedented risks. Our interconnected world has become a fertile ground to seamless criminal activity across borders, giving rise to a complex challenge of transnational cybercrime. The United Nations Trade and Development, UNCTAD, has reported that, and I quote, cybercrime is an escalating issue affecting nations across all levels of developments, impacting both consumers and businesses. The dynamic nature of cyber threats and the accompanying skills shortages pose significant challenges to law enforcement and judicial systems, especially concerning cross-border enforcement. Cybercrimes represents one of the most complex challenges of the digital age. It undermines the integrity of financial systems. It jeopardizes national security. It threatens democratic processes. It violates human rights. including the rights to privacy and dignity of individuals across the globe. Therefore, the theme of the present panel is vast and multifaceted. However, in the next 15 to 20 minutes allocated to me, I will focus on the 5 key issues. 1, general understanding of the scope and nature of cybercrime. 2, the role of the judiciary in combating cybercrime. 3, cross-border judicial cooperation in combating cybercrime. 4, current trends and challenges in judicial cooperation. 5, proposals for strengthening cross-border judicial cooperation. There is no single universally accepted definition of cybercrime, but it broadly refers to illegal activities that involve the use of computers, networks, or the internet to perpetrate or facilitate a crime. My researchers gave me an example where they said the Council of Europe's Convention on Cybercrime outlines offenses related to computer systems and data. And the new UN Convention Against Cybercrime aims to establish a global framework for defining and combating these crimes. Cybercrime is not a single offense, but rather a spectrum of unlawful activities enabled by or directed against digital technology. We can distinguish at least 3 categories. 1, cyber-dependent crimes, type 1, such as hacking, spread of virus or malware, ransomware, distributed denial of service attacks, that is, the flooding of internet servers to take down network infrastructure or websites, piracy, phishing. These can only be committed using a computer, computer networks, or other forms of information communication technology. 2, like fraud, cyber-enabled crimes type 2 are corporate espionage, extortion, human trafficking, money laundering, child exploitation or child pornography, where digital platforms amplify traditional offenses. Unlike cyber-dependent crimes, they can still be committed without the use of ICT digital technologies. They can still be committed without the use of ICT or digital technologies. The third category I referred to are cyber-facilitated harms. These include disinformation campaigns, cyberbullying, cyber-stalking, social engineering, catfishing, non-consensual pornography, also often referred to as revenge porn. In such instances, the perpetrator is using the digital platforms, especially social media platforms, as a platform to commit crime. As technology continues to evolve, cybercrime is also growing, with criminals becoming increasingly sophisticated and resourceful. What makes cybercrime even more uniquely challenging is its ability to transcend borders, as it occurs in the borderless realm of cyberspace. A perpetrator, and this might be very frightening, may reside in one country, route their attack through servers in another country, exploit vulnerabilities in a third country, and ultimately target victims in yet another country. The role of the judiciary in combating this kind of crime. The judiciary must ensure that cybercrime laws are properly interpreted, applied consistently, and adapted to the evolving realities of the digital age. While many states have enacted cybercrime statutes, their interpretation often raises novel questions. For example, what constitutes an unlawful access? How can digital evidence be authenticated? How should we balance free expression on the one hand, which is a human right, as we all know, with restrictions on harmful online speech? Courts across the world have had to grapple with these issues, sometimes extending the reach of domestic law into the digital space when online conduct has cross-border effects. For example, Indian courts have ruled that mobile phones fall within the definition of computers under the Information Technology Act, ensuring that tampering with mobile software counts as a cybercrime offense. In another case, the court set out conditions for the transmission and visibility of evidence obtained from encrypted platforms in cross-border criminal cases. Courts are guardians of fundamental rights. In combating cybercrime, states often resort to measures such as surveillance, interception of communications, or cross-border data sharing. These tools are sometimes indispensable in tracking cybercriminals, but risk infringing the rights to privacy, to due process, and free expression of others who are affected thereby. Landmark rulings from the courts demonstrates how judiciaries act as checks on excessive state power. For example, the European Court on Human Rights has reaffirmed that cybercrime investigations must still respect fundamental rights, ensuring that the fight against crime does not come at the expense of legality and human dignity. The court has thus reinforced the judiciary's gatekeeping role, ensuring that investigative powers in cyberspace are subject to proper judicial oversight. The judiciary also functions as a bridge between international commitments and domestic law. When states ratify conventions such as the Budapest Convention, the African Union's Malabo Convention, or the newly adopted United Nations Cybercrime Convention, it falls to courts to interpret and apply domestic statutes in harmony with these international obligations. Judicial interpretation, therefore, becomes the mechanism through which global commitments are translated into enforceable rights and duties at the national level. Courts contribute to building predictability and fostering cooperation across borders. A well-reasoned judgment in one jurisdiction can inspire others, promoting convergence in how cybercrime cases are handled. This cross-pollination of jurisprudence helps harmonize global responses to cybercrime and strengthening judicial cooperation. Courts reinforce obligations of both state and private entities in combating cybercrime. For example, the Bulgarian NAP cyber attack case of 2019 illustrates the vital role in this breach. Hackers stole the personal data of about 70% of Bulgaria's population from the National Revenue Agency. While the criminal act was prosecuted, the Bulgarian Supreme Administrative Court held that the state agency itself was liable under the GDPR for failing to adopt adequate security measures. The ruling emphasized that data controllers, whether public bodies or private companies, cannot escape responsibility simply because a third party carried out the attack. By recognizing non-material damages such as distress and fear of identity theft, the judiciary underscored that cybersecurity is a legal obligation tied to human dignity and trust. This case demonstrates how courts can strengthen cyber resilience by ensuring accountability and setting higher security standards for all data controllers. However, the role of the courts is not that straightforward. Given the nature of cybercrime, its transnational reach, high level of sophistication, and reliance on constantly evolving technologies, the role of the judiciary in combating this form of crime is complex. Courts cannot work in isolation. Instead, they must collaborate with a number of stakeholders, including lawmakers, investigators, prosecutors, experts in forensics, IT, and even international partners to ensure justice is delivered. Importantly, the role of the judiciary in combating cybercrime in the digital age is also an opportunity for progressive innovation to address emerging realities. In India, the judiciary has embraced procedural modernization by allowing the submission of electronic evidence in courts, even when it is stored in cloud servers of foreign jurisdictions. This is particularly important in financial fraud and online harassment cases, where digital evidence is often the only link to the crime. These examples show that in combating cybercrime, the judiciary's roles cannot be limited to the traditional function of interpreting and applying laws. Instead, courts should now be at the forefront of shaping how legal systems respond to the digital age, including, among other things, 1, institutionalizing specialized mechanisms of cybercrime, B, modernizing procedures to accommodate digital evidence, 3, building technical capacity to understand digital forensics, encryption, and online evidence trails, and 4, driving international cooperation by setting precedents that encourage cross-border collaboration, and 5, identifying legislative gaps that require reform. In short, the judiciary is not just an arbiter of disputes in cybercrime cases. It is also an innovator, a collaborator, and a bridge between technology and justice. By adapting in these ways, courts help ensure that the law keeps pace with the digital era, protecting individuals whilst also upholding fairness and due process. Cross-border judicial cooperation. Cybercrime frequently transcends national borders, making international cooperation essential. Effective investigations, prosecution, and adjudication often depends on collaboration between the countries, law enforcement agencies, and judicial institutions, supported by legal frameworks, international conventions, directions, guidelines, and recommendations. Then, we give a number of cases, the EncroChat case, which illustrates the needs for coordinated action. Evidence from encrypted devices located in multiple countries had to be transmitted, authenticated, and admitted in a cross-border criminal investigation. Similarly, in another case, Grillberry NAP cyber attack, it highlighted how data breaches affecting millions of individuals can have implications across European Union member states, requiring harmonized interpretation of general data protection regulation, obligations, and coordinated enforcement. Cross-border cooperation, therefore, is not limited to procedural matters. It also involves training and capacity building. Each actor in the justice system requires specialized skills to operate effectively in a globalized judicial environment. Legislators and judges need a thorough understanding of how proposed cyber laws interact with international obligations and cross-border investigations. Investigations or investigators require hands-on training in data recovery, encryption, decryption, and forensic analysis across jurisdictions. Prosecutors must be able to interpret digital evidence from multiple sources and present it convincingly in court. Judges must assess the admissibility, reliability, and the relevance of evidence gathered internationally, while understanding the technical context of cybercrime investigations. When all stakeholders are properly trained and equipped, confidence in cross-border cooperation increases. The law is applied consistently, and enforcement against cybercrime becomes more effective. Without judicial cooperation, cybercriminals can exploit gaps between legal systems, whilst coordinated action ensures that justice keeps pace with technology. One critical area is the extradition of cyber criminals. When suspects operate across multiple jurisdictions, transferring them from prosecution ensures accountability and prevents safe havens for criminal activity. For example, in the Encrotas case, we give citation, involved the cross-border investigation of encrypted communications, where coordinated efforts between France, the Netherlands, and other EU states enabled arrests and extraditions of organized cybercrime actors. Another key area is the mutual recognition and enforcement of court orders. Judicial systems must acknowledge foreign judgments, search warrants, and subpoenas to access digital evidence stored abroad. The Bulgarian NAP case, time is up, illustrates this need, as the cyber attack exposed personal data affecting citizens. The current trends, let me just go in the minutes that I still have, I believe, time. Judicial networks, such as the African Judicial Dialogue, the Igbo American Judicial Summit, and the European Judicial Network, foster communication and knowledge exchanges. They are also very important tools for experience sharing and learning. And of course, capacity building, the United Nations Office on Drugs and Crime should provide that facility. The strengthening of cross-border judicial cooperation. This can be done in the following ways. One, harmonization of legal frameworks. For example, aligning definitions and procedures to reduce conflicting laws, encouraging states to ratify conventions that provide for cooperation. Two, encouraging countries without cybercrime laws to adopt such legislation. Three, creating specialized judicial institutions dealing with cybercrime. Four, the adoption and ratification of robust international agreements. Five, judicial cooperation through clarifying territorial jurisdiction versus provider control to overcome obstacles in the trans-border acquisition of electronic evidence from cloud providers. And lastly, expedited cooperation mechanisms. We need to fast-track judicial channels, allowing courts to validate urgent cross-border requests for digital evidence, etc. In summary, therefore, ultimately, while appreciating the challenges that cybercrime poses, it is of utmost importance that any framework dealing with this threat must remain grounded in the rule of law and respect for human rights. I thank you very much for your kind attention.
예, 수고 많으셨습니다. 사이버 범죄 퇴치를 위해서 무엇보다도 국가 간 협력이 중요하다는 말씀이셨습니다. 오래된 그 법조 경륜이 연륜이 묻어난 아주 영감을 주는 좋은 발표였던 것 같습니다. 예, 드디어 준비된 발표가 모두 끝났습니다. 이제 토론을 하게 되겠는데요. 저희한테 주어진 시간이 3시 40분까지입니다. 그래서 그때까지는 끝낼 수 있도록 노력하겠습니다. 혹시 뭐 질문하시거나 말씀하실 분 계신가요? 예, 말씀하시죠.
Thank you. Jackie Wessels, Regional Court President in Limpopo in South Africa. I've been involved as part of trainers networks in cybercrime, international ones for judiciary and prosecution. The big problem with mutual legal assistance, either the legislation and or the protocols, even the South African one that's relatively new of 1996, it's old and outdated as far as cybercrime and electronic evidence related issues are concerned. It were all written in the days before this explosion that we have been seeing in the last few years. So, interesting enough, in a lot of continents where they have investigations that is cross-borders, the prosecution and police will prefer to do joint task teams because it's much, much easier and quicker to, as a joint task team, get all of the relevant evidence together instead of trying to work through mutual legal assistance legislation and programs. So the question basically is, how much do we need to consider the importance of adapting the way that we've been doing things in order to actually be effective in dealing with cybercrime and electronic evidence-related issues? Some mention was made about electronic evidence. In some of our countries, like mine, the development regarding the admissibility of electronic evidence is a bit convoluted. Can we try and say it like that? In terms of the old evidential rules, sort of it's supposed to be, depending on the circumstances, real evidence or documentary evidence, it's kind of rather ridiculous. And I do think it's time that we wake up about things like that as well. Electronic evidence really needs its own admissibility rules, in particular with regard to the way that things are these days and how you are able to get access to it. I mean, issues such as cloud, etc., were mentioned. Especially if you look in some areas, more the cyber violence related areas, where a lot of social media is being utilized, you have disappearing messages. You need to be able to get the relevant evidence, the access to that, in order to get the evidence, to have it, be that with even screenshots, etc. You need to be able to do that rather quickly, considering the nature of this kind of evidence and how it can be, for example, on a disappearing message. The other side of the coin is, you know, a freezing order does not really work when you are dealing with revenge porn and with child sexual abuse images, etc., making it kind of also difficult. So
For courts to be effective and for the judiciary in dealing with these cases, I do think we need to be very cautious in how we approach it and to understand that you cannot use a very old world attitude towards evidence and crimes that is using very rapidly developing technology. I mean, even your understanding about how crimes are being, cyber crimes in particular, is being perpetrated. Again, the use of AI within this. There's even been the questions raised about sexual harassment and assaults within virtual reality, and whether or not we've got legislation that adequately can cover the emotional and psychological harm that can be caused to people in situations such as that. Thank you.
예.
That's all for my comments.
네, 말씀해 주셔서 감사합니다. 혹시 패널 중에 답변하실 분 계신가요?
Yeah, certainly. I agree with, I think, everything you've just said, and maybe just add some observations to that. In analysing the problem, I think we have to perhaps begin with how we deal within our own legal systems with obtaining and regulating the access to the type of data, evidence and information you have been discussing. And really, it's only when we have actually come to a clear and settled position as to what our own rules are that we can move to the next stage of seeing to what extent we apply those in relation to requests from other jurisdictions to deal with the type of cross-border crime with which we have been concerned. And, I mean, these really are complex questions. You've put perhaps one side of the argument, but what we here in our court have heard in the last 3 years, where legal issues tend to come in groups in entirely disparate and seemingly disconnected ways, but we've had a number of cases in which we have had to navigate the application of old rules of privacy to entirely new situations. But the counterpoint that will be put, and that is argued particularly in Europe with considerable force by privacy advocates, is that for the state to have access through the simple device of a mobile telephone without any legal constraint on what the state can, or the prosecuting authorities or the police can interrogate, is to present a huge invasion of privacy. Chief Justice Roberts in the Supreme Court of the United States, which similarly has been addressing these issues over the last decade, points out, and it's obvious, that with a person's mobile phone, you can track information about their health, about their location, about their banking, about their music tastes, about their friends, together with a whole host of other aspects of one's own identity, dignity and integrity that certainly conventionally we would view as being within that phrase, the right to be let alone. So how do we regulate these issues? I mean, one of the arguments that was presented to us was that, okay, if the police are going to enter a dwelling and they intend to seize a computer, then they must disclose that intent to the warrant issuing judge when they seek the warrant. That's fine, and that's what we found. But behind that was another argument, that actually when they obtain the computer, they must obtain prior judicial authorization for what it is they can look at in the computer, whether by word searches or what they can access in the cloud. And that's a very difficult question. We ultimately concluded that no such constraint should be imposed, and that in turn met with a certain criticism from some. So I think we have to take it in stages, but absolutely the first stage is how do we deal with these matters within our own system, and there really are 2 points of view on that.
If you let me just add a couple of words. I do believe that anyway, in any type of legal systems, both in common law and civil law systems, whether you have the so-called stage of preliminary investigation or do not, still some police sections are in the background of the future of the case. And anytime they should be pretty quickly. But it is exactly this fear of cyber criminality where the sections should be immediate. If you can compare, there is a term of golden hour in ambulance practice. It is a very short time where very fast, very intensive, very efficient action should be done, and that saves lives. Almost the same is with the cybercrime. You should be very fast to get the evidences and to fix them. And later on the judges will deal with that, and the prosecutors as well. So probably the very first thing the international community should do is to work something out in this sphere. And it's a very important question about the electronic evidences. I would like to point out one more time that fabricating and falsificating of the court evidences is becoming a very serious problem in our legal reality. Sometimes it becomes industrially organized, you know, with high technologies involved and very expensive and efficient equipment being used. I face myself such cases. Sometimes they even seems to be funny and comical to you, but how stupid these evidence are, how anybody could believe this, but they stop to be funny for you when the court is going to consider this case, this evidences. So the international legal community definitely should deal with that and work out some new approaches to their admissibility and the relevancy of the court evidences. Thank you.
예, 감사합니다. 아까도 잠깐 말씀드렸습니다만 그 사이버 범죄를 퇴치하는데 필요로 하는 것이 그 디지털 증거의 수집인 것 같습니다. 네, 디지털 증거는 그 기존의 증거들과 달리 증거의 성질이나 증거의 내용, 증거의 양 등에서 기존의 압수수색 절차만 가지고서는 인권 보장이 이루어지지 않을 수 있을 것 같습니다. 저희 한국에서도 이 문제에 대해서는 늘 고민하고 그 적절한 조화점을 찾고자 노력하고 있습니다. 혹시 다른 질문 있으신가요? 질문 없으십니까? Sorry.
Yeah.
예. 감사합니다.
I'm Liesl Haupt from the Pretoria Society of Advocates in the Gauteng province, South Africa. And we've heard a lot about the responsibility of, obviously, of states cooperating, but also the judiciary being involved in interpreting maybe civil rights and liberties to assist with these cyber crimes. But what about the responsibility of the service providers or domains that provide or facilitate a breeding ground for these crimes? Can I please have the perspective of the panel on this, and where does the duty lie? Shouldn't there be more of a duty of care, in a certain sense, on these service providers not to facilitate or make available space for certain crimes to be committed, especially with regards to minor children and the distribution of pornographic material or facilitating the production of pornography? Thank you.
질문 감사합니다. 답변.
Thank you for the question. That is quite a problem, I guess, and not only dealing with the cybercrime criminality. Building some small bridge to our previous panel. Let us not trick each other. Just very short, comparatively short number of the idiots on our planet is making a damage to our nature just for fun of themselves or just because of their bad culture of behaving. Mostly dangerous and important damages to their environmental sphere are happening when the big and huge money are involved. So more serious financial or other interests is behind some activity. The more difficult is investigating of this activity and prosecuting it, and more serious is the crime itself. The same thing is in the cybersphere, and the liability of the providers, of course, should be regulated in some way, and of course, they should play some rules to get the access to the huge money on the markets that they do have right now, and probably will increase in a very close future. So this is one of the items that should be discussed by the international community and should be solved just probably in the very first row of questions to be solved, just as the police cooperation and courts cooperation. Thank you.
네, 답변이 됐을까요? 다른 뭐 말씀하실 분 계십니까? 제가 사회를 봐서 이렇게 조용하신가요? 그러면
Some cybercrime is going to happen, I guess. Let us stop it.
많이 피곤하시죠? 네, 그러면 오케이. 예. 여기 있네요. 예. 그럼 이제 토론을 마무리하도록 하겠습니다. 결론으로 본 세션에 결의안을 채택할 수 있었으면 좋겠습니다. 오늘 세션에서 논의된 내용을 바탕으로 해서 다음과 같은 결의안을 채택할 것을 권고합니다. 첫째, 사이버 범죄 퇴치를 위한 국제사법협력이 강화되어야 하겠습니다. 둘째, 상호 법적 지원 절차를 개선하고 실시간 대응 체계를 구축할 필요가 있겠습니다. 셋째, 법적 통일성 확보 등을 통한 공통된 사법문화 확립에 더욱 노력해야겠습니다. 그리고 마지막으로 사법부 역량 강화를 위한 교육이나 교류, 모범 사례 등을 공유하는 걸 더욱 활성화하게 해야겠습니다. 이러한 노력을 통해서 G20 사법부는 국경을 넘는 사이버 범죄에 대한 역량을 강화하고 글로벌 법치주의를 실현하는 데 기여하게 될 것입니다. 존경하는 각국 대표단 여러분, 우리는 오늘 이 세션에서 사이버 범죄라는 국경을 초월하는 위험에 대해 심도 있는 논의를 나누고 사법부가 어떻게 협력해야 할지에 대해서 중요한 공감대를 이루어냈습니다. 이러한 결의안은 단순한 문서에 그치지 않고 우리가 모두 함께 지켜야 할 약속이자 앞으로의 실천 방향이 될 것입니다. 각국 사법부의 지혜와 협력은 사이버 공간에서의 정의와 법치를 굳건히 세우는 힘이 될 것입니다. 이 자리에 참여해 주신 모든 분들께 깊이 감사를 드리며 오늘 논의가 앞으로의 협력에 이어져 실질적인 성과를 만들어내기를 기대합니다. 이것으로 제4세션을 마치겠습니다. 감사합니다.
Let me add my appreciation and thanks to this last session. Thank you very much. We are requesting that we break for 15 minutes exactly. We want to finalize the resolutions document to incorporate what has just happened in this session. And then we will then continue with the program. The team will be placing a QR code where you can access the draft resolutions by scanning the QR code, and then you'll have access to the document. Our request is, when the Chief Justice convened the first virtual meeting, she confirmed that we are a democratic nation. So we are democratizing this process. That's why we're giving you access to the draft resolutions. And you were all here, you've had each session facilitator summarize what came out of each session. And the team has captured those resolutions as they were summarized by the session facilitators, with one or two improvements here and there. I'm saying this to say, when you have access to the draft, please be mindful that we are a collective. We are summarizing what came out of this collective. Please restrain the urge to domesticate the resolutions, to resonate with your own situation. I hope you understand what I'm trying to say. We captured what this collective has said, and then look at it. If you have suggestions to make in terms of revisions, please keep that in mind. So could we then break for 15 minutes exactly, and then we'll come back and then go through the resolutions document. Thank you very much.
translation, because I will speak in more lovely language in the world. Até eu... Wanna sit here or no one sit in the middle? No? Yeah, I sit because of the. Yeah, maybe in the middle. Thank you. While some colleagues are coming in, maybe I can just introduce myself. My name is Laurinda Cardoso. I am from Angola. I am from the Constitutional Court of Angola. I am the president. I'm in charge for 4 years. And I will obviously speak in Portuguese. So, as most of you know, Portuguese is a very quickly language. I will talk slowly to give the opportunity to the all translation get the point of my message. Thank you. Ok. Veneranda Juíza Presidente do Tribunal Constitucional da África do Sul, excelentíssimos presidentes dos tribunais supremos e constitucionais, membros do J20 e presidentes convidados, caros magistrados, minhas senhoras, meus senhores aqui presentes, distintos colegas, guardiãos da Justiça Constitucional, como foi dito ontem pela Presidente Maya, os sentinelas da sociedade, aqueles que garantem que os poderosos sejam levados à justiça e que os vulneráveis encontrem a sua voz. Fim de citação. Eu tenho a honra de presidir esta penúltima sessão, digamos assim, e gostava de, antes de tudo, apresentar, em nome do Tribunal Constitucional de Angola e no meu próprio, uma palavra de apreço e de profundo agradecimento à nossa anfitriã, veneranda juíza Presidente Maya, e por seu intermédio a toda a equipa do Tribunal Constitucional da África do Sul e todos os membros que intervieram, quer direta ou indiretamente, para o sucesso deste evento. O nosso muito obrigado pelo vosso caloroso acolhimento. Este magno evento que nos uniu nos últimos dias está na sua reta final. Ao longo destes dias, partilhamos experiências, desafios e visões sobre o papel transformador da justiça em tempos de mudança. Agora, é tempo de consolidar todo o diálogo que aqui foi feito em resoluções e que essas resoluções possam refletir o nosso compromisso coletivo. Presidente Maya, sentimos aqui o verdadeiro sentido de Ubuntu, a filosofia africana que nos ensina que existimos através dos outros. Eu sou porque nós somos. Portanto, esperamos que essa filosofia deve guiar a nossa cooperação também. Não são só os 20 tribunais do G20 isolados. Somos uma comunidade global de guardiões constitucionais que devem se manter unidos pelo compromisso sagrado com a dignidade da pessoa humana. Com efeito, tendo em consideração que os nossos tribunais coletivamente influenciam a vida de mais de 2,5 milhões de pessoas, cada decisão que tomamos ecoa através de gerações. Cada interpretação constitucional molda o destino de nações. Esta é a magnitude da nossa responsabilidade partilhada. Como tivemos o prazer de testemunhar, o tema que nos reuniu, independência, inovação e cooperação, não é apenas um lema, é um chamado à ação. A independência judicial continua a ser o pilar da democracia, mas hoje ela exige coragem para enfrentar novas ameaças, desde a desinformação das redes sociais aos ataques internacionais, como os juízes, que muitos juízes dos nossos membros enfrentam. Por exemplo, atualmente, os juízes do Supremo Tribunal do Brasil, até a erosão dos direitos fundamentais. Como aqui foi enfatizado durante a primeira sessão do dia de ontem, a independência do juiz não o coloca acima da lei. E enquanto juízes, somos os guardiões, não do poder, mas dos princípios. A inovação, por sua vez, não se limita à tecnologia. Ela inclui novas formas de interpretar a lei, de proteger os vulneráveis, de tornar os sistemas judiciais mais acessíveis e humanos e, por sua vez, a inteligência artificial. Os dados da digitalização são ferramentas que, como vimos na nossa segunda sessão de ontem também, podem reunir longas peças processuais, organizar documentos e compilar dados em apenas minutos, deixando o juiz livre para efetivamente julgar. Mas o coração da justiça continua a bater na empatia e na integridade dos nossos tribunais. E a cooperação? Nunca foi tão urgente como vimos na terceira sessão das questões relacionadas com as mudanças climatéricas. Exigem uma resposta conjunta, pois não afetam apenas um Estado, afetam o mundo. A justiça constitucional não conhece fronteiras. A última sessão de hoje deixou patente que quando partilhamos jurisprudência, podemos partilhar boas práticas e a solidariedade contribuem também para a construção de pontes que fortalecem o Estado de Direito em todas as nossas jurisdições. É com este espírito que eu introduzo a nossa próxima interveniente para a apresentação das resoluções da Cimeira J20. A resolução, portanto, será apresentada pela excelentíssima senhora Presidente do Tribunal de Recurso da África do Sul, a Presidente Mahube Molemela, aqui presente. A Presidente Molemela é a quarta Presidente a liderar a Corte. É uma incansável defensora da igualdade do gênero e da justiça social. É membro da Associação Internacional das Juízas e do Conselho Consultivo do Centro de Direitos Humanos do Estado Livre. A Presidente Mulemela tem um currículo muito vasto e nós, como temos que gerir o tempo, eu nem sequer vou ler todo o seu currículo, porque os senhores iriam questionar a idade da Presidente Mulemela. Então, para que essa questão não seja colocada, vou só frisar aqui um aspecto muito interessante da Presidente Mulemela, que além de integrar uma orquestra sinfônica, a Presidente Mulemela tem uma carreira que já começou há 38 anos. Portanto, há 38 anos a Presidente Mulemela já foi procuradora, já exerceu a advocacia, já exerceu atos de notariado, já exerceu atos de conservadora e é com ela, com a Presidente Mulemela, que nós vamos ter o prazer de, com atenção, ver então a primeira base da resolução desta reunião. Presidente Mulemela, por favor, a palavra é sua. Muito obrigada.
Good afternoon, ladies and gentlemen. I stand on the protocol that has already been observed. Good afternoon, and thank you to my dear sister from Angola for your kind words. Ladies and gentlemen, it has been a long day. I don't plan to make it longer than it should be. My task is a very easy one, really. You will recall that you were informed that before the 4 broad topics were adopted in relation to the theme, Justice in a Time of Change, Independence, Innovation and Cooperation, the Chief Justice, in her democratic nature, called a virtual meeting where all the participating judiciaries were allowed to give inputs in respect of the topics to be discussed, and 4 broad topics that have formed part of the discussion yesterday and today were agreed upon. So there was consensus in relation to the topics, and we intend that there should also be consensus in relation to the resolutions that are adopted. Global problems that are faced by all the judiciaries were discussed, and solutions were proposed by various members of the panel, and there were also contributions from the floor. So it is these identified solutions that were discussed at this summit that form part of the draft resolutions. You will note that the draft resolutions are couched in broad terms, and that's deliberate, so as to reflect the key points of what was discussed in order for us to be able to easily agree on what should be part of the resolution. They were made available by way of being uploaded, and a QR code was provided, and I hope that during the break you had sufficient time to have a look at them, to apply your minds and to decide whether they resonate with the views that we shared here, such as to be adopted as resolutions. The intention is to leave this room with firm resolutions. However, we are now going to go through them one by one, the text of the draft, and we invite views from the floor as to how they should be tweaked. As my brother, the Deputy Chief Justice, has already indicated, we should be mindful that we are a collective, so in tweaking, let us just be careful that we don't end up now putting form over substance. So we will go through them That is the preamble. Let me establish whether there is any delegate in this room who has any issues with the preamble as presented. Thank you. Thank you.
Chief Justice.
Okay.
Thank you very much, and thank you for all the efforts. I just want to draw the attention that we have not received the draft at an earlier stage whereby we can provide our comments. So we are not in a position, as a G20 member, to agree to this so far, because again, we have some comments that we can share with the Secretary of the conference. That's why the phrase here at the preamble, we're not in a position to agree, that we participants agree to these resolutions. Again, we wish we had received this earlier. Thank you.
Thank you very much. I hope I will be able to clarify to an extent. The summit started yesterday, so the draft resolutions could not have been prepared before the summit because they have to be points of discussions that emanated from the summit. It is for that reason that only this morning were the first 3 sessions, the draft resolutions summarized and put up on the QR code, and the last bit could only be added at the conclusion of the presentations this afternoon. So I'm not sure whether we could have done it any better, unless you are maybe suggesting that 15 minutes was not enough, and in which event you can indicate how much time you would need to have a look at them so that you can make a more meaningful contribution. But if this is maybe of some comfort to you, we are going to go through them. So the preamble does not matter much because at the end of the day, it's not going to constitute the resolutions themselves. So may I suggest perhaps that we start going through the text, and then you can indicate, in as far as the draft resolution themselves are concerned, maybe let's park the preamble for now, if that's fine by you.
Thank you, Chief Justice. As we speak, we are providing the Secretary with our comments, detailed comments, and I don't think 15 minutes was enough, to be honest. If other members are fine with that, at least as a G20 member, we indicate that we are not in agreement with these resolutions unless our comments are addressed. Thank you.
Thank you very much. There's another hand. Please go ahead, sir.
Yes, Robert Reed from the United Kingdom. I have a great deal of sympathy with the position of the representative of Saudi Arabia. I'm not in the least critical of those responsible for drafting the draft resolutions. They are a very good piece of work produced in a very short period of time. As draft resolutions and a basis for discussion, they are first class. But I don't think we have enough time now to go through carefully quite a lengthy document, which, at least in my jurisdiction, would be regarded as important and might be relied on in legal proceedings in front of us. If I commit the UK to these resolutions as they stand, as I say, litigants, well-organized ones, will rely on that in court. Now, my own preference would be to discuss these as draft resolutions, finalize them this afternoon as draft resolutions, and then allow a period of time, perhaps 14 days, for further comments to be submitted and the resolutions finalized.
Thank you. Thank you very much for that contribution.
I think,
may I establish?
May I say something from India? Yeah?
Yes.
I think I would second Lord Reed on this, because the first paragraph, see, we represent the judiciary. So any comment which will have political overtones, we will not be able to commit because we are an independent organ of the government. So particularly paragraph 1 of the preamble. I understand your point that preamble is not part of the resolution.
Yes.
But it's a preamble to which we, give our concurrence. So apart from the time factor, if we can stick to para 2 onwards, para 1 being a general comment of the preamble, para 2 are the topics that we have discussed.
Yes.
So that falls in line with our, representation coming as it does from the judicial wing of the government, judicial wing of the state, not even the government. So if you can think of that also, it will help. Deleting para 1 and proceeding with from para 2 of the preamble in the draft resolution.
Yes, thank you very much. That's very helpful. I do want us to consider the suggestion that has been made by the 2 delegates from that side. I'm just trying to establish whether there are other hands. I know time is against us. My brother, Justice Nzebeza, will attest to the fact that when we were in Algeria at a conference, we came to this critical stage because the resolution stage is the most critical stage of any conference, I believe. And we came to that stage and we were provided with the draft resolutions as they have now been presented to you. And I was one of those who had an issue in relation to one of the resolutions that were proposed precisely on the same basis as mentioned by my brother from India about the political overtones, bearing in mind that here in South Africa we have a judicial code of conduct that precludes us from pronouncing ourselves in respect of political matters. And the matter was debated at length. We took a break. I think the break ended up being a break of nothing less than an hour and a half debating that specific aspect alone. And in the end, it was left out of the resolutions. Now, we did say there will be a democratic process. And I think if we want to be democratic, we should then apply our minds to the suggestions that have been made. The hope was that we shall depart from this venue having adopted the resolutions, but the view is that we can agree on the draft, on the proviso that final resolutions will only be taken within 14 days. May I get other views from other delegates, please, and then we can hopefully make a decision with the benefit of all the inputs. Justice Kolapen?
I didn't put my hand up, but that's fine. So it seems that we have to navigate between 2 imperatives that come out here. The one is a clear indication from some delegates that our final conference document should avoid, as it were, traversing what is political and confining itself to a question of the content of the 4 sessions. And I think that shouldn't be a problem. I think we could set out the context with regard to why we gathered here. This was the forerunner to the J20 heads of summit meeting, etc., and judicially meet something more neutral like that, and that's certainly possible. I could imagine people might have difficulty with a statement that says we're moving towards populist authoritarianism, etc., and they might say, well, that might be so, but as judges, we don't want to associate. So let's be sensitive to that. I do think that out of the 4 sessions, there was a summary by and that forms, as it were, the basis of the heart of the resolutions. Perhaps rather than trying to draft today and redo that, because many colleagues have said they want to reflect on that, we should see whether there's a mechanism we can adopt that perhaps allows us to do that in a short space of time. I don't know, but be guided also by what perhaps the CJ and the DCJ might have to say on this issue. But we did say we want to be democratic.
Yes.
But at the same time, we also want to while we have all our delegates here, see if we can capture the essence of what we had agreed upon, if that is at all possible.
Yes, thank you very much, my brother. That's helpful. If I may just add or reiterate that this is a product of the committee that was tasked with capturing the draft resolutions as they were coming from different sessions. You'll recall, if you look at the program, you will see that at the end, it had the part where the facilitator, the session facilitator, had to give an input on possible draft resolutions emanating from each session. I was made to believe that each facilitator was asked to give an input afterwards, and that this document is a consolidation of all the views that were presented or that came out from that kind of exercise. So my belief is that the content of the draft resolution will broadly be aspects that were touched on in the discussions in this room. I don't know whether we could maybe try to at least utilize this time fruitfully in terms of doing part of the work and then leaving the balance in terms of the final resolutions for later. The Chief Justice seems to be having something to say. Oh, DCJ, thank you.
Thank you very much, President Mulemela. I think I wanted to explore the time element as well as the suggestion of a process. Because what seems to be coming out is colleagues need to apply their minds to this document. It's not a long document. The suggestion on the table is 14 days. Personally, I think 14 days could be a bit on the long side, but I think we should be sensitive, as Justice Kolapen suggests, that maybe let's find a way of agreeing that colleagues apply their minds to the document and send in their suggested changes so that the drafting team can then look at what comes back and come with a document that reflects the suggested changes. I was going to suggest that, because maybe if we were trying to debate now, the issue will be people haven't applied their minds to the document. They've just got it, but it's in our democratic nature. We could not have come prepared with a document without having heard anyone speak. That's how we operate in this country. So this document arises from what we said here. That's why it's only coming now. So I'm basically saying to colleagues in the room, there's a suggestion to apply minds to the document. There's a suggestion of 14 days, which I think is a bit long. Can we agree a period and agree that suggested revisions be then sent to the drafting team to look at, consider, and then come with a revised document that reflects the suggested changes?
Yes.
Thank you.
Thank you. And the Chief Justice wants to add. Chief Justice?
Just to concur in my brother DCJ's proposal and emphasize the concern about the length of time proposed, the 14 days. And I want to make a counter proposal of 7 days, which I think would be adequate for all of us to apply our minds and come up with a satisfactory document.
So if I marry the suggestions coming from the two of you, it seems you are suggesting that the draft submissions or the draft resolutions will stand as draft resolutions, and that colleagues will send their comments. Colleagues who are so inclined will send their comments to the email address that was provided earlier on, and the drafting committee, together with, there are judges in the, who are members of the drafting committee, so we will together have a look at the proposed suggestions, and then a revised document will be provided within 7 days and be circulated And if there are no further views, in the absence of further views, that document shall then constitute the final resolutions adopted at this summit. Yes.
Thank you. I just to clarify this suggestion, it's only suggestion, because we need to know, I think it's for Saudi Arabia, yes, and UK,
India.
and India. And maybe we can ask for the other colleagues what they think about. And it's important for us also, even we can agree to give more time, 1 week, 15 days, whatever. It's important to know what kind of suggestion, ratification we can do. Like we are still now at the preamble. What is the problem with preamble? Maybe Saudi Arabia could say, okay, if we change the sense of the sentence, I don't know if the problem is the citizens or the leaders, or we can replace it to jurisdiction because we are talking about judiciary. Maybe, I think we need more. Not only say that I don't agree, the time is not enough. We need more. Otherwise, we will stay a week, a month, and we don't have a resolution. I think we need more. We need to talk more about which kind of substance we don't agree, or which kind of changing we must make, because we need to give support to the technical team to make the last version. I think it's my opinion. I don't know.
Thank you.
I had made a concrete suggestion. Para 1 may go of the preamble. Para 3 may come in as para 1, and para 2 now may go in as para 3. It falls in place. Yes. We don't have to get into para 1 at all. So that's a concrete suggestion.
Yes.
I made
Thank you very much. Thank you very much. It is duly noted. It will be taken into account when a revised draft is circulated.
Can I add one observation?
The colleague from Saudi Arabia has indicated that they have already submitted their comments, so we'll be having the benefit of their comments in that document.
Yes.
Singapore.
Yes.
I think they put the Chief Justice and the DCJ summarized it very nicely to say anyone who wants to give input can do that. I would suggest that we perhaps go with the timeline that has been suggested by the Chief Justice, which is 7 days in relation to the submission of inputs, and then after 7 days, the revised draft will then be circulated to all the delegates. There was a hand this side. Singapore, yes, sir?
No, I was going to make the point that I don't think it'll be very meaningful to engage in a redrafting as we speak.
Yes.
And I mean, the adoption of resolution is not a personal view of the participant, because we represent our respective judiciary. So for my part, for example, adopting resolution would require a discussion with my Chief Justice. And typically, we do not participate in resolution also without some input from the Ministry of Foreign Affairs. So this sort of engagement is necessary. So, I mean, whether we can do it in 7 days or 14 days, the point is, I don't think it is, realistic to go through line by line to see how we should redraft the resolution. Yes. So we need time.
Yes, thank you very much. Point well taken. Thank you very much. There's another hand.
Sorry, I'm the next left wing of the participants of J20, so just a couple of words. I guess we really do get two ways of behavior. On the first one of them is to get the document which anybody shares. And their discussion and adoption of such a document is quite an ordinary thing, and it should go according to a diplomatic protocol, and probably it will not take only 7 days, probably it will take longer time, but we have another way as well. We can just fix in the document, and as far as I can understand, this idea is nowadays in the heart of your suggestions, that such views, such point of view, such suggestions had been articulated during discussions. That is quite easy thing. We can just, any of us can be the evidences, the witnesses of that happened, and that will not take a lot of time. We just need to check out the text just to find out that everything was put there correctly according to what happened on this conference during these 2 days. And but it should be stressed and pointed out in the text of this final document that these ideas are not shared by all the participants. They were just articulated, and that just happened. And I do believe that it is also a result. It is also a good efficiency thing that we can implement in the improvement of legal practices. Thank you.
Thank you. Thank you very much. Are there further hands? I don't see further. Oh, there is another hand. Yes. Ma'am?
Good afternoon. I'm Professor Ingela Schlemmer from Wits University here in Johannesburg. I just want to ask whether you will accept academic comment as well. You are talking about the delegates giving feedback, because I have a comment that I would like to make, if that would be allowed.
Yes. Inputs are from all delegates who attended, so you will be more than welcome to share your inputs. Thank you very much. If maybe I can summarize, my sister can assist me. If I can summarize that these remain the drafts because they are simply an articulation by the drafting team of what was discussed in the last 2 days. If an issue is raised about the accuracy or the correctness, then we will go back to the record and check to make sure that it is accurate. So if you have an issue with anything that appears here and you are of the view that it does not represent what was discussed in this summit, please let us know by sending an email to the email address that was provided. And Chief Justice, you had said 7 days. There's a view that 7 days is not enough.
I do backtrack on that proposal. I spoke on the basis of how we do things in South Africa. We don't have any other people to consult. We make the decisions for our own business. So I withdraw the 7-day proposal.
All right. So you'd be amenable to 14?
Yeah.
14? 14. 14. Anyone against 14? Okay. So it will be 14 days. These are the resolutions. They're still available on the QR code. Those who have to go and consult with their constituencies will go and do that and will submit their inputs. All inputs will be taken into account, and based on the inputs received, a revised document will then be shared with all the participants, and we will take it from there. Thank you. Thank you very much for your time. Much appreciated. Thank you.
During 2011 and 2012, I presided over expert group meetings in Vienna. And when I heard these submissions from the floor, some horror stories arose in my mind. But fortunately, we found a mechanism and a process to agree a solid document. So thank you very much for those inputs. We've come to the last point of this program, and I want to refer to a very rich Zulu saying in South Africa, which says, "Injobo itungelwa ebandla." That saying, in simple terms, means to transact important business, you can't do it alone. You do it with others. That's what we've done. We congregated here as a collective. And we congregated to take stock of our current context as members of the judiciary in what we do. And in doing so, we spoke and we listened. And we've found commonalities in a number of things. We looked at our independence, which is an existential premise for us as members of the judiciary, for us to do our work without interference. And interference does not only mean personal interference, it means threats, intimidation, etc. We've dealt with that. We've also considered that to remain effective and efficient, we need to embrace innovation, because innovation has been recognized as a serious enabler, and AI has been recognized as a tool. Though dangerous, but we all have agreed that we can control it to make it help us to be more effective and efficient. And what resonated throughout, especially in the last session, was the need for closer collaboration in the context we are in, a borderless context, that things can be done by someone sitting somewhere, affecting someone sitting somewhere else. So having come to this stage, mine is to simply thank you all for having responded to the Chief Justice's call for you to come here. And we hope we've been able to live up to expectations in giving you a platform to talk. And we've certainly learned from some jurisdictions that are far ahead of us in terms of implementing some issues in our processes. So thank you very much for that. And mine is to simply invite the Chief Justice of the Republic of South Africa, Chief Justice Mandisa Maya, to come and close the proceedings formally. Chief Justice.
They say time flies when you're having fun. It's hard to believe that we are at this stage. Program Director, Deputy Chief Justice Mlambo, esteemed colleagues, distinguished guests, ladies and gentlemen, good afternoon. As we draw the curtain on this historic gathering, allow me please to express on behalf of the South African judiciary our deep gratitude and sincere appreciation for your presence, your invaluable insights, and your spirit of collaboration over these past 2 days. This gathering has truly embodied our shared commitment to justice in a time of profound change. Our meeting in the iconic and dynamic city of gold is a monument to African ambition and progress, and showcases the continent's growing influence on the global stage. We came from every corner of the globe, literally, each of us carrying the weight of our constitutions, the hopes of our people, and the immense responsibility of adjudicating in an era marked by radical change. Our summit was guided by a theme both timely and profound: justice in a time of change, independence, innovation, and cooperation. In our engaging and fruitful deliberations. We breathed life into these words to give them substance and meaning and found unity in their necessity. We stand at a unique inflection point in human history, not very far from the point of singularity, it seems, with the rapid rise of artificial intelligence redefining creativity and personhood, and make it clear that human affairs cannot continue as we know them. The climate crisis threatens the very habitability of our planet. Geopolitical tensions are stretching the foundations of the international rules-based order. Inequalities fracture our societies, and misinformation erodes the fabric of public trust, as we've said before. The demand for justice becomes more urgent in such times, and it falls upon our shoulders as the guardians of the constitutional order and arbiters of the rule of law to meet that demand. How we do this lies in the theme of the summit, and the following are my takeaways from the discussions we've had. First, judicial independence. This is our non-negotiable foundation. Judicial independence is not a privilege granted to the judiciary. It is a right vested in the people. It is the guarantee that every person, from the most powerful to the most vulnerable, will be heard by an impartial arbiter, free from fear, favor, or prejudice. We have shared stories of the pressures that seek to compromise this independence, be they political, economic, social. Our discussions have reaffirmed that our independence is not preserved by silence or isolation, but by unwavering integrity, transparent reasoning, and the relentless pursuit of principle. We must be the stable ground in the shifting political sense, the guardians of the covenant between the state and its citizens. Our independence is the bedrock upon which all else is built, and we must defend it, not just for ourselves, but for the sake of every person who believes in justice. Second is innovation. To be steadfast in principle does not mean to be stagnant in practice. The tools of our judicial systems need to be adequate for the challenges of the present. We must innovate in how we dispense justice, how we manage cases, and how we communicate our judgments. We have heard inspiring examples, courts using AI for case management and legal research, while fiercely protecting human judgment in the adjudication of core rights. We have heard of virtual courtrooms expanding access to justice to remote communities, of plain language judgments being disseminated through social media, or of data analytics being used to identify systemic delays in justice. Indications are strong that innovation, while always risky, as it is usually a leap into the unknown, is not a betrayal of tradition. It is its evolution. It is how we ensure that our courtrooms are vibrant, accessible, and efficient centers of 21st century justice. We must embrace technology as a tool to serve our mandate, to listen, consider, and judge fairly. Third is cooperation. The challenges we face know no borders. Climate change, cybercrime, the rise of AI, and threats to judicial independence are issues that do not respect jurisdiction. No single court, however powerful, can address these in isolation. The old adage, unity is strength, remains true and relevant. But then this summit is born of cooperation between our nations and now us. We have built bridges of understanding across legal traditions. We have shared experiences, practices, and jurisprudence, not to copy blindly though, but to learn from one another's wisdom. A ruling on digital rights in the Americas can illuminate a case in Europe. A precedent on environmental rights from Africa can inspire a court in Asia. Cooperation allows us to stand together in affirming universal principles. It creates a global network of judicial wisdom that can resist the parochial pressures we may individually face. Let us strengthen these bonds and keep the channels of communication open for continuing dialogue and collaborative research on global challenges such as we discussed here. The J20 occupies a unique and critical space in the global architecture of governance and is distinguished as one of the very few official G20 engagement groups that are an integral organ of the state itself. So our mandate is not merely advisory, it is foundational. Our dialogue concerns the very bedrock of our nations, the rule of law. We are custodians of our constitutions, the independent arbiters upon whom the entire edifice of a functioning democracy depends. Therefore, our presence here is a powerful reaffirmation that justice is not a secondary consideration, but the primary condition for lasting stability, economic prosperity, and human dignity. Our discussions have not only highlighted challenges, but they also inspired resolutions that will guide our jury, resolutions when we do finalize them, resolutions that will guide our judicial institutions in their vital work ahead. The profound success of this summit lies in the quality of our discourse and the strength of the collegial bonds we have fortified. We have transcended mere diplomatic exchange to engage in a deep sharing of jurisprudence, challenges, and innovative solutions. This collaboration is the lifeblood of a resilient global judicial community. There seems to me to be an issue which at some stage may have to be considered to institutionalize the results of these gatherings and ensure that the resolutions adopted at these gatherings are carried forward effectively and the initiatives they birth are realized. One fully respects the decision of the G20, which operates on the model of rotational presidency, not to have a permanent secretariat. But there may be a gap arising from this arrangement for our engagement group in particular. A lack of continuity and preservation of institutional memory, which a permanent secretariat or another office with some degree of permanence could provide. But I leave the matter open, hopefully for discussion on another occasion. But it is something that I think is worth thinking about. I wish to thank our facilitators, speakers, panelists, and organizers for making this summit the success it has been. A special word of appreciation must go to Deputy Chief Justice Mlambo, who so ably directed the program with grace and precision, and of course the organizing team which arranged this magnificent event for us. The team in my private office, led by Mr. Jacobs, and the entire team in the office of the Chief Justice, led by Advocate Secretary General Marilise Potgieter. You have truly done us proud and made me look good among the nations. Thank you. As we depart from this venue, hopefully with a sense of renewed purpose and a concrete resolve to build the structures that will secure the future of global judicial cooperation well into the future, let us view this moment as a new beginning, a beginning of the Centennial Accord, and live with the resolve to fortify our independence with courage and integrity, champion innovation to make justice more accessible and effective, and deepen our cooperation, knowing that our collective wisdom is our greatest asset. In the language of Nelson Mandela isiXhosa, sithi mazenethole nisiqumile nasenza abantu ndlelanhle, which simply means thank you and farewell. It is now my distinct honor and privilege to declare the 2025 Judiciary 20 Summit closed.
privileged